আসছো না কেন? Yes, any mentioning?
Restoration application, man. That's I have sub notice.
Hand over. Notice with notice. Which group? You have to wait for a while, Mr. Chandra. I'll take it up. Only restoration. Ki nicho? Application. Yes, hand over.
My lord, motion.
Which group?
Group 6, my lord.
Group 6 motion. Wait, what is there in motion? 2017?
2021.
Yes.
21.
What is the urgency?
My lord, urgency is.
And why is it motion? Was it moved?
My lord, my matter was.
2021 I cannot take up. I don't have determination.
It is what waiting for.
I don't have determination. Yes.
Waiting for Mala in the list to put the other put Mala. Then Mala.
No, wait, sir. Yes, any other mentioning?
May I have your lordship's kind to the application?
Mala take it up any date, Mala.
Our order was
Wait.
Our order was first to deposit 10% of the amount, Mala, within 10 days. That 10 days, Mala, expired on Mala 10th of April. We could not, Mala, because of Mala, there's a server problem. We could not, Mala. We need an extension for 7 days, Mala. Any
Take out an application.
Any date we mentioned, Mala.
We mention how can I alter? What is the order? Where is the order?
This is the order, Mala.
Who's the other side?
Where
is your notice?
No notice has been annexed with this one. I can inform them, my lord.
You did not comply with this direction. 1st April direction you did not comply with.
Malad, what happened, Malad? Malad, this is Malad, the second appeal, Malad, that the Malad tribunal has not been set up till date, Malad. So, Malad, we came before Malad, his lordship, Malad. So, Malad, his lordship, Malad, statutorily, we have to deposit 10% of the Malad, another amount for the appeal, Malad. So, 10% we have to deposit, Malad. But we cannot within 10 days, Malad, there is the problem, Malad, there is a problem, Malad.
Where is your pay order?
Malad, I can bring, Malad, if your lordship, Malad, on Malad, to.
Oh, with the authorities. Deposit it with the authorities first and come.
Malad, if your lordship, Malad, did not extend, Malad, but there's a difficulty in portal. It is with difficulty in the portal. I have to deposit through portal.
Wait now. Hey, where is your notice?
That is Malad, annex, Malad. There is Malad, last page, Malad, we have emailed, Malad. And I can inform, Malad, again, Malad, to them, Malad.
No, this WhatsApp will not do. Where is your notice? Sorry, sir. You served notice. Advocate of the Calcutta High Court, you served notice on the respondent.
I know.
Not acceptable.
But I can come back, Malad, tomorrow after giving notice.
Whatever, you serve notice and come back.
With your lordship's leave, may I be permitted to mention a writ petition for inclusion of list, your lordship? It's a GST cancellation matter, your lordship. The only urgency is that my client had given them the reply. They did not consider my reply and they had cancelled my GST retrospectively. If your lordship can keep any
Is
date.
it an appealable order?
Yes, your lordship.
Then?
No, it's not a appealable order, sorry.
It's not an appealable order.
No. Yeah, Justice Nizamuddin had heard our matter once, but my clients wanted to get some instructions, so he had kept it for not today and asked us to mention before another court in the next week.
Madam, wait for a while. Let us see. Your matter is required to be heard on an exchange of affidavit is required. You cannot get an interim order. And it's unlikely that I can take up next week because from next week I was
going to port.
So I can take it after I come back.
So may I mention it in the month of May? Or
yes. I'll take up your matter. Unless urgent matters, I'll not take up on this side.
It is an urgency. My client cannot conduct their business.
Madam, when was it cancelled, madam?
2023, your lordship. November.
Today we are in the year 2024.
It's in the month of November, your lordship.
So, madam, there is no urgency now. If there was no urgency in November, December 2023 and in January 2024, you cannot have a special urgency in mid-April 2024. You have to wait for a while. Yes.
Grateful, your lordship.
Lord, I'd like to mention a matter, my lord. The petitioner, senior citizen, my lord, praying for regularization under the Umadevi. Lord, the petitioner prays for regularization under the light of the Umadevi judgment. My lord, it was appearing in the list.
You asked for, you are seeking for?
Not for inclusion in the list, my lord.
Arey, what is your prayer in the writ application?
Ma'am, my lord, the regularization for under the light of the Umadevi judgment, my lord. For
Where are you working?
Uh,
Where are you working?
Lord, under senior, my lord, Mr. Farooq Ali.
You are working for your senior. Where is the petitioner working, sir?
Lord, I'm not very well versed with the brief right now, my lord.
Get ready and come back, sir. Yes. Any other mentioning, Mr. C? Yes.
Subject to the leave of the court, my lord, this is notice upon the other side. I being the, and it is running in the lordship list, item number 112 of the monthly list.
What do you want?
My lord, in my case, I being a retired person, I am deprived of my retirement benefit. And moreover, my lord, I being a senior citizen, suffering from the cancer patient, my lord.
From when it is appearing in the list under the heading monthly list? From when?
My lord, it is running in the list. 1 month back,
So why did you not mention earlier?
my lord, the other, my learned.
No, don't mention before me. Yes. Call this. No, so no, not now. Not now. Mention in May.
We mentioned item number 1. My lord, this is not the correct item,
Yes.
my lord, but I am constrained to move, my lord. This is a mentioning for original side, my lord.
No, not
Because-
now.
Because my lord had directed to appear this item as item number 1, my lord. In today's, this is a contempt matter which my lord had directed me to remind of, and it was directed to be appearing today as item number 1 in the original side.
It's not
My lord,
appearing.
It's not appearing in the list at all, my lord. That is the only reason I had to.
Is there any direction in the matter?
No, my lord, on the previous day, this is a bridge and roof gratuity matter. The other side had come up with a new Wakalatnama, and my lord had directed me. The
It will
item,
appear. No, no. Mention in the afternoon. It will appear tomorrow.
my lord, only that is the reason I was mentioning.
দেখেনিন কেন আসেনি? Sorry, sir. Do not mention now.
Heard the matter. My lord has heard the matter and it was been assigned. And after that,
Sir, which year, sir?
my lord, it is a case of the 2020.
Was it called on the day before yesterday?
No, my lord, it has not yet.
121 was not called on? কি মামলা দেখি? দেখি ফাইল দেখি?
Not lordship.
No, wait. ফাইল দেখি, ফাইল দেখি, ফাইল দেখি।
I am a cancer patient, having age of 74 years. Lordship, kindly consider.
Sir, if your matter has been called on, I will never call it up. And if you make an incorrect statement in court, sir.
I beg to apologize for the inconvenience.
Assign matter, assign matter.
No, no, my lord, it is not yet assigned. Right now,
Then why are you making an incorrect statement in court?
my lord, yes, this matter was assigned. to the-
Sir, I don't have determination in respect of 2022 matters. Yes, call the list.
Manoj, if I may be,
Unnecessarily you are mentioning without checking up the list.
Manoj, if I may be permitted, the
Yes.
Group 4 matter related to tax 2023 writ petition, direction for affidavit given made returnable in the month of January. My lords, you have mentioned in between, but the matter is not coming up.
It will come up in May. Mention. It will come up in May. Yes. any
I am
other
mentioning
mentioning?
for correction of an order dated 8 April 2024 by Honorable
Justice?
Justice Nizamuddin.
Yes. What is the correction you have?
Correction is.
Who is appearing on the other side?
36. My senior
Take it,
son
file it.
comfortably has admitted to the hospital for this kind of action for the up to May.
Let me understand what is the correction he is asking for. It's a correction.
Another,
It is not a correction.
another matter.
Why are you mentioning? A mentioning is going on. What is this going on? He is mentioning a matter. দিয়ে দাও, তুমি mention কালকে। Where is your notice?
What is it in the
দিয়ে দাও কালকে তুমি। Yes, what is the mentioning?
36 serial number. My senior Amjad Ali Mandal admitted to the hospital, Delhi.
You don't want to do it.
So I action for up to May.
Wait, when it is called on. Yes, call the next first matter.
We mentioned item number 1.
None at the time of call, none appears on behalf of the parties. Now, although this matter has been assigned, at the time of call, the parties are not represented, full stop, in view thereof, to provide one more opportunity to the parties to present their case. Let this matter stand adjourned and appear in the monthly list of May 2024. এটা মে মাসে পাঠিয়ে দাও। হ্যাঁ। আর নাহলে একটা কাজ করো, এটাকে কালকে রাখো। হ্যাঁ, নট টুডে, এটা অ্যাসাইন তো, কি বলতে চাই দেখি। হ্যাঁ, নট টুডে থাকলে এটা কালকে রাখো। ইয়েস, কল দি লিস্ট। দেখি ফাইল দেখি।
Number 2, my lord.
এটাও অ্যাসাইন তো। They are not there. Today is the date for fixing a date for hearing actually. I'll keep it tomorrow, Mr. Dotto and Mr. Sarkar. Come tomorrow. The other matter I've adjourned it. I thought I'll place it in May. But let me understand from them what they are interested, whether there is any urgency or not, since this is an assigned matter. Come back tomorrow, please. Yes. Not today. Yes.
For motion item number 3.
For the respondent.
My lord, I am for the petitioner. I am want to withdraw this writ petition because some notification was not annexed the writ petition. My liberty may be given to
What is the formal defect?
my lord.
What is the formal defect in the writ
My lord,
application?
the petitioner wants to challenge the notification which was published in.
Challenge it.
My lord, the notification.
I'll permit you to
Gra-
withdraw.
Grounds also not there. Kindly give me liberty may be given to file afresh. My lord.
Challenge the virus, the grounds for virus have not been.
No.
The notifications he has not. He wants to challenge. He has not taken.
The learned advocate representing the petitioner on instruction submits that he does not wish to proceed with the present application. He does submits that there are formal defects in the instant writ petition, and as such he prays for leave to withdraw the same. Full stop. Such prayer is not opposed by the learned advocate representing the respondents. Full stop. Having regard to the same, let the writ application be dismissed as withdrawn with liberty to file afresh on the same cause of action, if so advised. Yes, next.
Item number 4.
My lord,
ওখানে কেন দিকে হচ্ছে?
my lord, I am for the petitioner. My lord, I am led by Mr. Pranit Bagh. He's on legs, my lord. I am praying for a not today.
Very well. Since an accommodation has been sought for on behalf of the petitioner, let this matter stand adjourned and appear in the monthly list of May 2024.
My lord, my lord.
How can I accommodate you on this side? Only one this first week. I'll take it up. Sir, I am not shy. Whatever is your case, either you, if you have something, you will get it. If you have nothing, it will be dismissed.
My lord, I was
So-
saying, my lord, if it can be kept tomorrow, my lord.
No. Let me get hold of the list. All the matters have not come. There are several matters.
Hello.
Okay, all these matters have not come up in the list. And these matters also, these were appearing before His Lordship, the Honorable Justice Nizamuddin. So from there, I had directed only first 10 matters to be listed. There are other matters. So for the timing, let me understand. Maybe some matters may have special urgency. I do not know. Let me call it once.
Great.
Only those matters I'll pick up. Rest of the matters I'll pick up. So these has been waiting for quite some time. Yes.
Great.
May.
Item number 5.
Lord, I am for the petitioner. My lord, I've been led by Mr. Anna. He's online, man.
May it please your lordships.
Yes.
My lord, I'll be appearing in this matter. My request is that I can come to Kolkata and then appear before my lords physically. So
Yes.
25th April, if that can be accommodated, my lord. I'll come from Delhi.
I'll sit in first week of May because I'll be there in circuit. So it will be easier for you.
Sure, my lords. I will.
I've
Whatever a fixed date may be given, I can plan my tickets and booking.
It will be taken up. If it is there in the first 10 matters, you can be rest assured it will be taken. Ordinarily, it is taken up. Ordinarily, sir.
No, that is true, my lord. A date may kindly be date, whatever date. My lord is convenient.
Supplementary list, I will not place it for now. I'll place it in the monthly list. Check up. then what happens? Then I'll fix it. At your instance, I'll fix it.
Grateful, my lords.
Ask your junior to mention the matter. I'll fix it with the urgency. since an accommodation has now on the prayer of the learned advocates representing the petitioner, learned advocate representing the petitioner, let this matter stand adjourned and appear in the monthly list of May 2024.
Grateful.
Grateful.
Item number 6.
My lord.
Yes.
Lord, this is a challenge to a show cause. May I just briefly tell your lordship, my lord? Well, the petitioner deals in commodities.
Yes.
My lord, was issued a notice in September 2021 by the Audit Commissionerate, my lord, for undertaking an audit for the financial year 2017-18
Where is the show cause notice?
to 1920. My lord, page 57.
If served on all the parties?
Yes, yes. It had appeared on the last occasion, my lord, when they sought for an accommodation. So it was thereafter matter was directed to come.
What is the interim order you are seeking today?
Well, I'll tell you, lordship, my lord, this show cause notice, there is no jurisdiction for issuance of the show cause notice. The matter which was settled in the audit, and look, there was a input tax credit that I availed of to the extent in a little in excess of 5.46 crores. I reversed it. And thereafter, to the extent 22 lakhs, to the extent I availed of the input tax credit, there was a finding by the audit committee that you have incorrectly availed of the input tax credit. So you are required to pay interest on that. I have paid the interest. So the audit committee, there is a committee called the monitoring committee. The monitoring committee in the final audit report has accepted
This
that.
is the statutory committee.
Absolutely. Has accepted that. So, my lord,
Is
that
the provision under which this committee is set up?
My lord, is possibly under section 65.
Very well.
My lord, then this issue has reached a finality. Now, in 2021, in 2023, I stand corrected, my lord. The notice has been issued saying that there has been discrepancy in the return for the financial year 2018-19. But this was in 8th November 2023. Thereafter, I give a response, and on the basis of that, a show cause notice has been issued. The show cause notice is dated 7th of February 2024.
Yes.
My lord, without going into the fact, now the show cause notice is also on the same ground for which the audit
Where is
committee.
the show cause notice?
My lord, it's at page 57. If I may just draw your lordship attention once to the audit committee's report by which it was finally settled. If my lord will kindly take once. Well, the observations at page 28 of the audit committee. I just take 2 minutes of your lordship's time.
Yes, yes.
Page 28. First paragraph at page 28, observation 1. May I just place the first paragraph? On scrutiny of GSTR 3B return for the month of July 18, filed on 18th August, it has been found that you have availed excess ITC input tax credit on account of IGST amounting to 5 crore 46 lakh and unutilized 22 lakhs. Thereafter, in the month of August, GSTR filed on such and such, you have reversed an amount of 5 crore 46 on account of IGST cumulatively adjusted from CGST and SGST. Finally, you have wrongly availed and utilized ITC amounting to 22 lakh, which attracts interest liability for the in-between period of availment and reversal. So, my lord, my reversal is accepted. Now, my lord, if your lordship will kindly come to page 38, the final audit report. At 38, my lord will find that this is the final audit report for the period from April 18 to March 19. The date your lordship will find towards the bottom of that page. And this is the final audit report of 23rd June 2022. If I may just trouble your lordship with page 40. Bottom of page 40, there is a heading called Gist of Objection. There your lordship will find on scrutiny of taxpayers GST 3B return for the month of final such and such amounting, your lordship will find the same amount of 5 crore 46 has been referred. and utilize 22 lakh thereafter. The sentence is that's thereafter, which was filed on Atut. The taxpayer has reversed an amount of 546 on account of IGST, cumulatively adjusted the 7, and also finally taxpayer wrongly availed, which attack interest liability in between. Now,
Very well.
if your lordship
Fair
will
enough.
kindly see the taxpayer's reply and then the recommendation. I have said I have already paid the interest as well. Then, my lord, kindly see the recommendation of the audit group. The above payment has
What
been
is
paid.
MCM?
Monitoring committee. That's the monitoring committee meeting, MCM. Now your lordship will see the recommendation. It says the above payment has been verified from
Yes,
such
I've
and
read
such portal. Then, so well, this is now your lordship will see my present grievance. If your lordship will see, there are two notices, which is at page 49 and 53. 53 is the substantial amount. If your lordship will kindly take 52 once. 52, I stand corrected.
Yes.
At 52, well, this is the under 73 subsection 5, they say that based, this is the discrepancy, intimation of liability, then your lordship will kindly take the third paragraph starting
50?
during scrutiny.
54.
At 52, my lord.
P7.
52, yes, P6, my lord. Should be, well, this should be a notice from the office of the superintendent GST, and your lordship will see there's a date on the signature, 7 December. Kindly, my lord, take the third paragraph starting with during scrutiny of GST 3B.
Yes.
For the period April to March, it is observed that ITC availed by the said taxpayer under GST 3B such and such is more than the ITC auto-populated under GST 2A. Well, these are forms which are uploaded. Table 10 and 11 against import of goods. The taxpayer has availed excess credit amounting to 3 crore 91.
It's a separate figure. The previous figure was 5 crore and all.
5 crore. So now they have found discrepancy of 391, already covered under 546. I've reversed it.
How do I know that?
Period. It is the
those
period. April 20 to March 19.
Page 65 has not given those documents.
This is my first point. Otherwise, I will also show the show cause is not maintainable.
Show cause, so far as show cause is concerned, give reply to that show cause.
Now, I'll tell you, Lordship. Now, my lord,
What is the difficulty on your part in giving reply to the show cause?
I had initially, my lord, this one.
You are apprehending any coercive steps to be taken against you.
Absolutely. Now may I just indicate this? May I just indicate this?
Are going on.
May I just indicate this?
Under which tenet
This
of
is
law will force
my first contention is that this is covered under the audit report. The period, it is the return period. Transaction wise is the return. My final return has been filed.
Go and respond to that.
I have. If your lordship will
No,
see.
show cause you have not responded.
No, my lord, what I have done is.
When a show cause has been issued?
My lord, prior
7th of February 2024.
Yes.
You respond to this show cause. I'll extend the period for responding to this show
No,
cause.
I'll tell you, Lordship. Well, apart from that, they don't have the jurisdiction to issue the show cause. My lord, kindly take the date of the show
Show
cause.
me that.
Kindly take the date of the show cause.
7th February.
7th February, page
It is not
57.
77, it is 31st March. I only see the last page, page 66. That's the digital signature.
Okay, 31st March. Very good.
31st January. 31st January.
Where, which page?
Page 66. The digital signature is
Oh, it's 31st January. I see.
31st January.
Very good. Yes.
They have put this.
Whether the date is given by them, I don't know where.
There's a digital signature according to.
You may give this is the date of issuance. If your lordship will see the date, he cannot say that. Kindly see the 57.
My
This
lord,
is the
I
notice
will-
that
I
you've
will
given
tell
it to
me,
me.
You shall file a short affidavit.
I'll file an affidavit, my lord.
You file a short affidavit.
Because why I tell you, under the act.
Let him file a short affidavit. This is the only cause of action is today, apart from the main primary issues that you have argued.
Yes.
You see,
Audit already settled. He is
Mr.
giving me a
Bose,
notice
that
for
I will not go into at this stage. You give reply and come back. You give reply and come back. And so far as this date is concerned, you say if it is beyond the period, it is without jurisdiction. Correct. Now let them file an affidavit. Short affidavit report.
and my lord, not to proceed with the show cause.
How can
I'll tell you. Now, how I'll tell you?
unless you are in a position
I'll-
to demonstrate
My lord,
that
kindly
this
take-
is without jurisdiction,
Absolutely.
I will not pass.
Wholly without jurisdiction. Kindly
Show
take
me.
section 73.
No.
Kindly
No.
take section 73.
GST দাও একদম 2017 কেন নিলে? বললাম তো কারেন্টটা আনিয়ে রাখ। ওটা ওখান থেকে নাও, ওখান থেকে নাও, ওইটা আনাও, ওইটা আনাও, জিএসটি একটা নাও, কারেন্ট আনাও। Section?
My lord, I take 73.
Yes.
This would be under chapter 15,
Yes.
demands and recovery. Now, if your lordship will see, this is the power with respect to which, my lord, notices can be issued. My lord, if your
Yes.
lordship will kindly take subsection 2. The proper officer shall issue the notice under subsection 1 at least 3 months prior to the time limit specified under subsection 10 for issuance of the order. Now, my lord will kindly take subsection 10. It says the proper officer shall issue the order under subsection 9 within 3 years from the due date for furnishing the annual return for the financial year to which the tax not paid, short paid, or input tax wrongly availed or utilized to the within 3 years from the date of erroneous refund. Now, my lord, kindly take subsection 9 once. The proper officer shall, after considering the representation, if any, made by the person chargeable with tax determination of the interest such and such, whichever is higher due from the issue an order. Now, my lord, if your lordship will kindly see the date, my lord, kindly take once. Now, this period has been extended by a notification. My lord, kindly take the notification at page 71. What they did is, for the financial year, 18-19, which is our relevant financial year, it has been extended. No, 18-19. 71, my lord. I stand corrected. 71. 18-19, my lord, the date of issuance of the show cause notice has been extended till 31st of January 2024. My lord, now your lordship will see this period is for my GSTR final return was filed on 30th of December 2020. So it takes us to 3 years, so 31st of December 2023. Now, by virtue of the notification, at best, it is extended till 31st of January 2023. No more than that. And you have issued it on the 7th of February.
That is what the affidavit would be of.
So, prima facie, I show your lordship.
Sir, boss, you see today,
Yes.
you see today, if you can succeed, they are authorities. They cannot change their stand.
No.
I can't
They
change
can-
their
digital
signature. I can't. They cannot change it.
What date?
Date, sir?
You can change the date. May issued on the
I will
notice.
also take into consideration another aspect after the affidavit. I know mine. I know mine. I will come. Actually issued and sent. I have the judgment. I have the judgment. I will argue. You will argue that. I will hear you on that. But for the timing, you have to put it on affidavit. Otherwise, this is a short question.
Absolutely.
The present writ application has been filed inter alia. And in the
Challenging-
meantime, if they want to file the reply, they may.
No, I don't want to. Without
prejudice, I'll
jurisdiction,
provide
why
for
should
that.
I file it?
I'll provide for that. I'll provide for that. Without prejudice to your rights, certainly. Because after all, you see, if you do not succeed in this, then there's no point. Everything gets delayed. If you succeed, everything goes.
I completely appreciate, my lord, but where? My lord, there is,
The
we
present
are
writ
talking
application
about
has been
inherent
filed
lack.
inter alia challenging a show cause notice purportedly dated 7th February 2024, issued under section 73 within bracket 1 of the Central Goods and Services Tax Act 2017, post of Mr. Bose, learned advocate, by drawing attention of this court to the aforesaid show cause notice, which is at page number কোথায় গেল রে বাবা? 57. Page number 57 of the aforesaid writ application submits that the said so cause notice had been issued on 7th February 2024 full stop, has been issued on 7th of February 2024, full stop. According to Mr. Bose, according to Mr. Bose, no, full stop. 7th February 2020. এই লাইনটা কেটে দাও, এই লাইনটা কেটে দাও। By referring to by referring to the provisions of section 73 subsection 2 and section 73 subsection 9 and 10 of the said act, it is submitted that the proper officer is obliged to issue a notice under section 73(1) of the said act at least 3 months prior to the time limit specified in subsection 10 for issuance of the order, full stop. By referring to, ওই প্রথমটা কিন্তু থাকলো, by referring to a notification issued by the Government of India Ministry of Finance dated 28th of November 2023, it is submitted that the central government had purported to extend the time for issuance of, where is that line, Mr. Bose?
My lord, page 71.
Yes, which
My
particular
lord,
line?
if your lordship will see,
Herein after,
towards the bottom, the last 3 lines.
yeah, I get you. Yeah, yes.
Government of India recommended an extend the time such and 7310. Issuance under such and such recovery of tax wrongly availed of specific in the manner as stated below.
হ্যাঁ, কি বলছিলাম?
না, এটা তো order, এটা তো order.
না, না, এটা order একটা, এই
At the 3 months prior to the order
of-
takes us to 30th January.
of a notice under section 73
30th January.
10 of the said act.
দুটোই লাগিয়েছিল, দেখো দুটো ডেটের Shobhaj is 3 months তো
This notification gives
Extends the time limit
time for
specified
passing the
under
order.
subsection
And
10
my
of
lord-
the said act.
There is a notification, my
My
lord.
lord,
which extends it.
subsection
Up to which date?
I'll tell you,
Extension that I can't find here.
Well, I'll tell you, Lordship.
My lord will
30th
not-
April is the date of the order, your Lordship will see.
Yes.
So subsection 2 read with subsection 9 and 10 of section 73 makes it clear that they have to issue the shoka 3 months prior
I
to
get
passing
you
of
that.
the order.
That part is
So
okay.
30th April minus 3 months
No,
takes us
you
to
have said it
30th
is
January.
extended till.
30th April, Roman
Yes,
1,
yeah, I get you. It's in the bottom.
correct,
Yes.
bottom, Roman 1,
Has been
30th
fixed to
April.
extend the date for issuance of an order under subsection 10 of section 73 of the herein after referred to the said act. Now, has the mean pleased to extend the time limit specified under subsection 10 of section 73 for issuance of order under subsection 9 of section 73 of the said act for recovery of tax not paid or short paid or input not paid or short paid or input tax credit wrongly availed or utilized, relating to the period relating to the financial year 2018-2019 up to 30th April 2024. Having regard to the aforesaid, it is submitted that the aforesaid show cause notice is beyond the time specified, and as such, no proceedings on the basis thereof would be initiated by the respondents. Full stop. Mr. Kankani, on the learned advocate.
May I have your Lordship kindly? May I have
Yes,
your
yes.
Lordship kindly?
I am just, Mr. Bose, I am only permitting you to pass, to file the objection to the, your response to the show cause notice
Without prejudice to my rights.
and contention. This issue shall be considered.
And subject to the result of the writ petition.
Yes, yes, yes.
Great.
Learned advocate representing the respondents on the other hand submits by drawing attention of this court, by once again drawing attention of this court to the show cause notice purportedly dated 7th of February 2024 submits that the said show cause notice had been issued on 31st of January 2024. Full stop. He submits that the digital signature appearing at page number 66 of the said application would demonstrate digital signature of the additional commissioner Yes, additional commissioner. He is the additional commissioner. Appearing at page 66 would demonstrate that the same has been issued on 31st of January 2020. First, having regard to the aforesaid, it is submitted that the same having been issued 3 months prior to the date for issuance of an order under subsection
73(2).
9 of the said act, not 2, 9 of the said act. 9 of the said act. The same is within the competence of the authorities, having been issued within line time of Puradam.
My lord, it is
73(2). No, the same is same. There is no irregularity. Same is not. There is no irregularity in issuing the same.
My lord, 73(2), not 73(9).
73(2), my read with 9.
Yes, 2.
He was arguing 9 and 10.
Most of them. Since a disputed question has disputed question will without. Or the learned advocates appearing for the respective parties, since the only question that has come up for consideration before this court as regards the date on which the aforesaid notice has been issued, aforesaid so-called notice under section 73(1) of the said act has been issued. I am of the view that the respondent should be permitted, should be directed to file a short affidavit. Let such affidavit be filed within a period of
3 weeks. My lord is anyway coming.
Within a period of 3 weeks from date. Reply, if any, thereto be filed within a week thereafter. Pendency of the aforesaid writ application shall not stand in the way of the petitioner.
My lord, the affidavit will be only on this short point, or would
You can
be
file it.
comprehensive?
Pendency of the aforesaid writ application shall not stand in the way of the writ petitioner responding to the show cause notice. Time is expired.
My lord.
Time has expired.
Show cause notice, full stop. If a response is filed by the petitioners, if a response to the aforesaid show cause notice is filed by the petitioner, actor petitioner is filed by the, how many petitioners? Only one.
Only one.
Filed by the petitioner within a period of
7 days.
Within a period of 7 days, within a period of 15 days from date.
My lord, there is one difficulty in this matter, my lord. My lord, timelines, the notification has.
I'll extend it.
Because yes.
I will extend it. Within a period of 15 days from date, the same shall be accepted by the respondents. Full stop. The aforesaid reply to the show cause shall be without prejudice to the rights and contentions of the petitioners in the present writ application. Full stop.
Orders may be passed. The order will be passed within 30. It has to be passed within.
All steps taken by the respondents shall abide by the result of the writ application. Full stop. List this matter. Liberty to mention upon exchange of affidavits. Liberty to mention. You mention, otherwise I do not know.
My lord, if they pass an order, then they will, if we do not comply, then they will take measures against us.
My lord has passed.
All steps taken by the respondent abide by the result. So that includes any order also.
Then my lord kindly keeps a date. Otherwise, this writ petition will never be heard, and this will be prejudicial to the
This
interest of
matter in the monthly list of June 2024.
Month is June.
Under the heading hearing. Mention it.
I will.
I have passed it. You see, negotiation of injunction in these cases. But he has made out a point. Now, if everything goes, you see, today, if you are not in a position to demonstrate that it has been.
If it is 7th February, I am out.
You know,
if it is 31st March, he is out.
When otherwise, my lord, we have got a case on.
No, that I will not consider. I said, that is why I am extending the period. You respond to that.
Not at this stage. Otherwise, it becomes factual.
Everything, then whatever happens, you come to court.
Grateful, man.
Yes.
7. May I please alert? Lord, the petitioner had imported 108 pieces of copiers, Xerox machines from China. The duty was levied at 48 lakhs, which we paid.
What are you challenging? You first tell me and then you go back.
Caesar. Lord, after the Caesar,
I pray for affidavits.
Lord, there's a provisional. My learned friend will give his affidavit. Lord.
Under section
110, Lord. 10A, Lord, there can be a provisional release.
This is under the GST Act.
Customs Act.
Customs Act.
Customs.
Lord, 110M, Lord, there can be a provisional release. More particularly when, Lord, under 110(2), Lord, they have not given a show cause even after a lapse of 6 months, which is mandatory. Within 6 months, they have to give a show cause.
Apply. I'll grant you leave. Apply.
Lord, the provisional release is also there.
Hey, did you apply?
Yes.
Did you apply?
We have applied. We have
Where?
applied.
Show me you have applied.
Let them consider. Let
No,
them,
no, no. If they have applied, you have to consider this.
No,
I
no.
will. With his point is not correct, my lord. I will let him finish. I will reply.
No, if they have
These are prohibited goods according to
Lord,
me.
page 68 of my application.
110(2) will apply only if those are goods which are not prohibited.
what you have seized is prohibited goods.
It becomes prohibited for the simple reason, my lord.
I'll hear you. I'll come back to you.
It becomes prohibited for the simple reason they have imported the bill of entry that they have filed, new copier machines, printers, copiers machines.
These are prohibited items.
I'll come to that. They have imported that, misdeclaring that they are, whereas they have actually imported second-hand photocopiers, which are restricted, prohibited items. For that, you have to import these second-hand photocopier items. You have to take an authorization from the DGFT. Because they are prohibited items otherwise without license. They haven't done that. What they have misdeclared that these are new photocopier machines and they have been found to be second-hand photocopier machine. If that be so, then they become prohibited items and they are not entitled to that release under section.
When have you seized these goods?
Seized, my lord.
Then I see.
Then why is the provision 110 there?
Lord,
No, my lord.
The
tenth of
statute book.
October 23.
Why is the provision
That
110
also
there?
we have taken an extension, my lord. Will kindly see. This is the noting I have already got from the
You
customs.
tell me what is the noting?
This notification gives an extension
Customs Act now. Customs Act
to
96.
issue the show cause notice for another 6 months. That is specified in section 110. A further extension of 6 months has already been taken
For the purpose of?
for the purpose of issuance of the show cause notice.
So you did not issue the show cause?
No, issue. There is a time to issue show cause notice within 6 months of the seizure. There is also a provision.
So you are holding on to this?
I have to hold on to this because there's a much bigger racket that is happening and there are other seizures also. Well, similar matters have
You
been brought.
dispose of his application under 110A if he has made saying whatever you want to say.
That we have taken, the extension we have taken is for only 2 months.
No, please understand, sir. If they have made an application, if they, as they say, they are subject to whatever they show me. You have to decide that application.
Passes a direction then.
Yes, absolutely.
Consider
Sir, show me which page.
Page 68.
No, first Caesar.
Caesar it, Lord, at page 36.
You can't sit over this.
No, we are not sitting over it, my lord.
Yes.
This is not as simple as it looks.
Why will I go into this?
My lord.
Whatever you have to decide, you decide.
Yes.
But there should be something on pen and paper. You have seized it, you're sitting right over this. There's no disclosure by you. There's nothing by you.
By law, I can read. These are confiscable goods. This, since my lord, these are prohibited.
The order
goods,
under section
it will be
110(1). Very well. These have been seized. Now, where is your application under 110A?
My lord,
My
lord will
our
kindly see.
representation. Our representation, page 68. Lord.
Yes.
My lord will kindly see section 110 to
I
provide.
will not. You decide it, sir.
My lord,
What is your difficulty? You want the court to decide.
my lord.
It is for you to decide. I will not decide this at this stage.
Let this be.
You have issued a show. You have not issued a show cause. You are seeking an extension. I accept it that you are entitled to in law. There is no difficulty. Sir, show me that provision that you have to issue within.
I'll show it.
But first of all,
100
just a minute.
102, Lord.
68 is 110
subclause 2.
Subclause 2.
No.
Lord, within
Page
6
68
months.
is under 110A. Where is your prayer? Where is your prayer?
This is by paragraph 15, Lord.
Provision and release. Paragraph 11. Yes, I've got it. Willing to abide. Yes. Yes, sir. You have not decided this?
Let this be disposed of within a
Ah, you see, this is where is your provision? Show me in the meantime.
110.
Not for this matter, but I want to know.
My lord will kindly see 110 subclause 2 proviso.
Yes.
provided that the principal commissioner of customs or
Wait. Slowly. 110.
110 subclause 2 proviso.
Subclause 2. Yes.
May I start from 110 subclause 2 itself?
Yes.
May I place that, my lord, for my lord's convenience? Where any goods are seized under subsection
I've
1,
seen that, read, yes.
and so one section
Extend the period. You have said this has been extended.
has been extended.
The present writ application has been filed.
Has been extended.
I'll dispose of the writ application. The present writ application has been filed inter alia, challenging the failure on the part of the respondents challenging the inter alia, challenging the order under section 110 within bracket 1 of the Customs Act 1962. Mr. Blanco, foreign advocate representing the petitioner, by drawing attention of this court to the provisions of section 110 within bracket 110 clause. This is subsection or clause, sir? This is subsection.
Yes, subsection.
Clause.
Subsection.
Yes, subsection 2 of the said act submits that when a goods are seized, where any goods are seized under subsection 1 and no notice in respect thereof is given under clause A of section 124 within 6 months of seizure of the goods shall be returned to the person from whose possession they are seized. So it is submitted that notwithstanding the goods having been seized, by the aforesaid order dated 25th of August 2023, and 6 months having elapsed, and no notice under clause A of section 124 having been issued, the respondent should be directed to release the goods, to return the goods.
Provisionally.
Return the goods. Under 1(2), there is no provisional word used.
If there is no show cause notice.
Naturally,
Provisionally is
to return the goods. Full stop. It is still further submitted that the petitioner had also prayed for provisional release of goods by making an application in writing dated 31st of January 2024. Acta petitioner. 31st of January 2024. And in paragraph 11 thereof. দরকার নেই, প্যারাগ্রাফ 11 thereof দরকার, এত কিছু বলার দরকার নেই, ছোট ছোট না অর্ডার করলে হবে না। Full stop. The said application for provisional release under section 110(11), under section 110 within bracket A of the said act, the Customs Act, is yet to be decided. For contrast, the respondents, by drawing attention,
time to file show cause notice.
by drawing attention of this court to the proviso to section 110 within bracket 2 of the said act submits that the principal commissioner of the customs or the commissioner of customs, now it is within the competence of the principal commissioner of customs or the commissioner of customs to extend the time by recording appropriate reasons, by extend the time for issuance of the so-called under section 124, under clause A of section 124, by a further period of 6 months before the expiry of the original period of 6 months from the date of seizure. Full stop. By placing before this court a copy of an order. What is this order passed by whom? Additional commissioner.
Note sheet.
No, it's not an order.
The approve. Of course, it is an order.
Order. This is an order.
Yes.
By placing before this court.
Additional commissioner.
Approved
by the
before this court. An order passed by the additional commissioner. It is submitted that the time for issuance of show cause under clause 2, under clause A of section 124 has since been extended. The order dated 4th of March 2024. Full stop. Such order of extension has been issued within the original period of 6 months. Full stop.
No.
Original period.
No, my lord. No, my lord, it has not been. 25th August was the season.
Yes.
4th March.
Even the post facto can be.
September,
No.
October, November, December, January, February. It's 4th March, Lord. It's beyond that time.
No.
It's beyond the time, Lord.
Yeah, give him a copy.
They have not given us a copy.
Give him a copy. Yes.
4th March, Lord.
I'll record
beyond
it.
the-
Yes, yes, yes.
Huh?
Oh, it's
So they cannot claim, Lord.
এটা বইটা ওনাকে ফেরত দাও।
Release here, Lord. The proviso cannot come to their help now.
No, no.
Then I'll direct release, sir.
No, my lord.
Thanks.
6 months কোথাও হচ্ছে? August 25th হচ্ছে।
Within that
October, November.
period of 6 months, I could have understood. Lord. It's beyond that period.
My lord then allows me to come back tomorrow. I will come. No, my lord, there's a decision. There's a decision also for that.
Hey, what here? What I'm passing an order?
Man.
Why are you so upset on this?
If my
I'll keep these points open for a later stage. I'll dispose of this petition for the time being.
Lord,
I'll record this submission.
not time, Lord. They have not followed the statute.
Heard the learned advocates appearing for the respective parties. No, he, however, could not. Mr. Saxena, however, could not.
my lord will see the note sheet. There is also a specific request for that release also. That has also been there. It's given there.
He, however, candidly submits that the application dated 31st January 2024 ought to have been decided by the respondents. Ought to have been decided by the respondents. Full stop. Heard the learned advocates appearing for the respective parties and considered the materials on record. Full stop. At this stage, without going into the question whether the extension issued by invoking the proviso to
110
to section 110
across to.
কি বললাম at this stage by invoking the provisions of section 110 section 110(2) first proviso of the said act is valid. I am of the view that the present application can be disposed of by directing the respondents to take into consideration the petitioner's application and pass a reasoned order. Petitioner's application dated 31st January 2024. 31st January 2024. Full stop. 31st January 2024. Within a period of 3 weeks from the date of communication of this order. Full stop. Communication of this order by passing a reasoned order. Opportunity of hearing, no scope. No scope. By passing a reasoned order. Full stop. If the petitioner is aggrieved by the same, it shall be open to the petitioner to challenge the same in with the above observations and directions, the writ application stands disposed of. There shall be no order as to cause. That point is kept. An affidavit of service filed in court is taken on record. That point is kept open.
My lord, affidavit, since affidavit said not.
এই সে ওকে line দিয়ে দাও। এটা কোনটা ওনার বই ওটা ফেরত দিয়ে দাও।
So I have got my book back.
Yes, yes.
But
you see, unless I dispose of these matters, these will remain here.
Right.
So these can be disposed of.
My lord, and he gets an opportunity also again.
Yes.
Item number 8.
Hey.
Mate, please.
Mate, please, your lordship, I am for the petitioner. I have challenged the order in original on the ground there is a violation of the principle of natural justice. Your lordship, kindly just page 17, beseech your lordship to turn to page 17. Second paragraph, your lordship, the RTP is requested to appear with all relevant documents on 2nd of February 2024 at 11:30. That notice was not given to me. In the portal, there is no notice, your lordship, and the order was.
That I have to take it because that is the only, that is his only case.
That
Because this was the second chance.
Take instructions and
this is.
If it is not there, it's not there. It has to be something. And if it's there, my lord, then
নামটা লিখে দিতে হয় বাবু, এখন নতুন উনি তো
এই নামগুলো দিয়ে যাবে।
হ্যাঁ হ্যাঁ
Nine.
Mr. Rai is appearing in this matter. He was here. My lord, certainly in court one matter is called up. My lord, praying for short passover, my lord. Yes, my lord.
Yes, my lord. Last time also, my lord, they took time, my lord, not 10.
My lord, I'm praying for short passover.
I'm for the petitioner, my lord.
Well, as per my instruction, Mr. Rai. I'm not the impellent advocate.
My lord, I'm challenging the draft order. My lord, I'm challenging the draft order dated 15/3/2024, my lord. My lord, I'll please come to my lord. My lord, this order is not appealable, my lord. This is the draft order, but this order itself is totally defective on 3 counts, my lord. Even on merits, it is immerits, my lord. My lord, let me show you something before any order is, before the affidavit is, because this order can go straight for quashing, my lord. Because look at the order, my lord. Yeah. My only.
This matter stand adjourned and appear.
Great. নামটা দিয়ে যাবে নামটা দিয়ে দেবে
Let me fix this. Taking up the matters. The hearing matter.
নয়টা অর্ডার স্যার
One of this and I'll take up the
অর্ডার পাস
Let us see how it proceeds.
অর্ডার পাস এটা অর্ডার পাস
If there is a
আঠারো চার আঠারো একই হলো টেন
Your Lordship, the counsel appearing in this matter could not come to court due to a personal difficulty. So Your Lordship may kindly take up the matter tomorrow. Your Lordship, the matter had come up before Justice Mohammed Nizamuddin. We had submitted 2 documents to the learned respondents, and Your Lordship, it was for under consideration. So Your Lordship, it is a simple issue. The matter may be remanded back if if our
Kindly takes it up because the learned counsel called me up in the morning. He called Mr. Chakraborty also, and me also, my lord. Lordship kindly takes it up on the next date.
tomorrow, Your Lordship.
Thursday.
Thursday.
We are doing other matters also.
Thursday.
Tomorrow we'll be having the appeals coming up before the Honorable Chief Justice.
Your Lordship, Thursday.
Thursday. Grateful. Thursday. Thursdays will.
Grateful to Your Lordship.
Thursday.
Thursday, Your Lordship.
Because if your lordship is not making it not today, then my lord, I think my lord, it will be a month. Generally, we all revenue lawyers will be facing some difficulty because all the revenue appeals are taken up by the Honorable Chief Justice on Tuesdays.
And on Wednesdays,
Wednesdays we go down.
since I fixed it on this side on Thursday, I'll take it up. Otherwise,
Seven except Tuesdays, my lord. Tuesdays, my lord, because all these appeals are taken up by the Honorable Chief.
Wednesdays and Wednesdays.
Right.
Hearing matters can.
Yes.
Allow some group 6 matters.
Appearing for the petitioner, my lord. The service has not yet been completed, my lord, so I am not in a position to file the affidavit. Only one respondent.
Submitted on the service on the respondent or respondent. Service on the respondents is not complete. Stand adjourned and appear in the mark list of
The list of. Let the matter appear at the top of the monthly list, my lord, which is that.
Number appearing at the top.
Item number 12. Well, I am for the petitioner, my lord.
I am for the respondent. I would request some instructions in this matter.
Well, we are challenging the assessment order on the ground of that. But the assessment order has traveled beyond the show cause notice. They have issued the show cause notice on the ground of there is a violation of section 68 of the Income Tax Act. There's the cash credit. The amount has credited to 68, and they have traveled. No, that is a limitation. The TOLA Act, my lord, from 1st of April to 30th June, they have extended.
Difficulty is the assessing officer has not passed the assessment order.
In a
It has
face,
been
yes.
passed by faceless. It has been passed.
Additional difficulty.
It has been passed by faceless. Therefore, we have to get all the records.
But it's my humble submission before Lordship. My lord, I am not on the merits of the case. I am only kindly give us the opportunity to give the documents, all the documents they have relied upon, and kindly give the opportunity to appear before him and submit the relevant reply.
I do not know.
Well, I am not. Yes. No, only thing is that they have passed the assessment order. We have to file an appeal within 30 days from the date of the assessment order. Limitation may be.
I will extend it. If I ultimately I am not with you.
Yes.
Is there any bar in extending?
Yes, madam.
Is there any bar in extending?
No, there is no bar, man. There is no bar. This is not that's no Well, because there is a provision.
Customs appeals are there,
no,
section 39 or those are some difficulties are there.
Because of the judgment of the Singh Enterprise and subsequently GlaxoSmithKline.
Ultimately, but ultimately those judgments were later the Honorable Supreme Court clarified that it can still be extended. Section 14 always can be there. It's on the question of 14 to 29, whether the applicability of 14 to 21 was under consideration of the Limitation Act.
I think maybe
that it stands excluded. 28, 15 to 28.
So your lordship can extend any time.
So that is the MP Steel Corporation, my lord.
Yes.
MP Steel Corporation 2021 judgment. They have explained the section 14 of the Limitation Act.
I had the opportunity to consider all this in connection with a tribunal application, where following this, the Delhi High Court had said that this time cannot be extended, although our court had said it would be extended. Anyway, since an accommodation has been sought for on behalf of the respondents, let this matter stand adjourned and appear in the monthly list of May 2024. These matters will retain its position in the list. Rest assured. গ্রুপ চেঞ্জ হয়ে গেলে বলবে
For hearing group 6, item number 13.
My lord, I am for the petitioner. My lord, actually, Mr. Shomo Ray is leading me in this matter. And unfortunately, today he is having an acute back pain That's why he couldn't come to the court today. Yes, my lord. My lord, may I request your lordship to kindly grant not today, my lord? My lord, it will be very ten. My lord, can it be taken next week, my lord? Deeply obliged. My lord, may I pray for one indulgence? In accordance with the last order of your lordship, we have already filed the court fees of 12 petitioners, my lord. And also, my lord, I beg to submit this exception petition, my lord, as let it be kept with the record, my lord. Deeply obliged.
14 Lordship, on behalf of Mr. Oturu Banerjee, Lordship, I'm praying very short Passover, Lordship.
Your Lordship.
He's addressing before court number 1, Lordship.
No, Your Lordship. I'm being led by Mr. Shoma Mojumdar, Your Lordship. Our submissions are over, Your Lordship.
Lordship, very small matter involved, Lordship. In fact, we have addressed Your Lordship before, on the previous occasion.
Your Lordship had directed the 1998 file for the order, Your Lordship, on that ground.
He is addressing for Lordship.
Your Lordship, a short pass over, please. It's a very small issue, Your Lordship.
Lordship, it's a very small matter, Lordship.
Lordship, may keep it tomorrow in kindly, Your Lordship. Grateful, Your Lordship.
15.
Matter is ready for hearing and there is an interlocutory application. That is also.
Malad, on the last occasion, Malad, it was deliberated, Malad, by both the parties that the matter will be heard finally. And therefore, Malad, there is no question of any interlocutory order application being heard today. But we are ready with the hearing, Malad. He may commence, Malad.
Lord,
applications practically are not disposed. Order requires to be passed. Further order requires to pass at this stage.
Because, Malad, as I had made submission, this is identical to another application filed earlier, which was dismissed. Now he has filed another matter, Malad. So, Malad, kindly do not go into the question of interlocutory order, Malad.
Finally, I will hear.
So, Lord, I am ready for Lord, to argue this matter today.
But I am also ready to respond. But if your lordship wishes to keep it in May, Malad, your lordship may keep.
No, accord Lord, as per Lord, my Lord's convenience.
No, my convenience is always there. You want to see
Lord, let me start from the application also, Lord, because Lord, something is there, Lord, so far as the application part is concerned. Lord, the records is.
Yes, Malad.
You have the record.
Malad, record I had produced on the last occasion, Malad. my lord, it was directed, my lord, vis-a-vis the application. Yes, but yes, but my lord, my affidavit is there, my lord.
Will only help you.
Very well, my lord. If it is not concluded today, my lord, I'll get it.
List this matter along with
Blood, the kindly fix any day, blood, in the month of May, blood. Yes.
very limited matters. Matters that most of them are already released from parents. So these matters will be applicable.
Blood, blood, the my lord, be pleased to direct parties to this proceeding to submit their written notes of argument.
Fine, I'm not finally heard it. What will I do? As it is, there are so many documents to be.
Not only 3 and 4 law points, I will take this in this matter.
Already money is secured.
Blood, money is secured, blood, so far as the interest parties.
Get it.
Yes.
But I will not permit it. Cover this money by way of an interim measure, that nothing remains for the man. Then your application practically is allowed, and the writ application is also allowed. You know, as an advocate, you should understand this. And your client will be saying so many things to you.
No, no.
But you should know that where you stand. Today it is secure.
Yes.
What do you want, sir? Finally, the matter
Yes.
has to be heard.
Blood, after, blood, at least after 10 years, blood, the money has been secured. After 10 years. And my client, yes.
Earlier, he filed the same application, it got dismissed.
No, blood, and not
They
dismissed.
did not prefer an appeal. Then they came up with another application.
Every day, blood, this wrong submission is being made. Blood, I am submitting to your lordship.
Yes. If it is to come up in May, we'll argue in May.
Why you wanting to spend all your energy today?
Get from
Next.
Item number 16, what is the development?
But we have given a letter, Lord, indicating about the stand of the port trust, my client, concerning, Lord, the pay scale to be, I mean, the stipend to be given to the trainee marine officers. But because of, Lord, the year ending and all, Lord, my client says that they will require around, Lord, 4 weeks time, Lord, to reconsider that.
I'll place it in May.
Very well.
As prayed for by the parties, list this matter in the monthly list of May.
Well, I have only one prayer. Small one. Kindly, my lord, fix our date, my lord. Monthly list of May, my lord, is very dicey. As
No, now it is no longer. It is up to 2017 determination I have. I don't have other determinations.
my lord is also now taking up the, my lord.
Group 4 matters.
My lord,
So I'll be dedicating a particular day for
Second
this.
May,
It
my
will be
lord.
easier for you also.
2nd May, my lord.
No, I'm not fixing it. Second May as it is, I'll not be here. I'll be here after 5th. So I'm not fixing it. Maybe after monthly list of May, I will be fixing matters. So let me get hold of how this takes shapes, these group 4 matters, then I'll fix it.
Grateful.
Great.
As prayed for by the parties, list this matter in the monthly list of May 2020. In the meantime, you take all steps.
Yes, Lord, we have, even yesterday, I'm told, Lord, he has given an email, Lord, reminding, Lord, my.
I think it will be resolved.
In all probability.
And so long as Mr. Mukherjee is there, I'm sure it will be resolved.
I'm having the same hope.
Yes, yes.
I'll try my level best. Grateful.
17 and 18. Kindly looks into your lordship's previous order.
Lord, I am playing 1 week time more, my lord. Because all that matter is ready, but not yet affirmed. Therefore, I am playing.
Provident fund matter, madam.
Statement is ready, my lord, but not yet affirmed. Therefore, I am playing 1 week time. Take it in.
May I request my learned senior friend to give me an advance copy so that I come back?
Serve him a copy now. Advance copy, madam, if it is not necessarily it's to be a true copy. You might alter it also and give him the final copy.
I'll keep Wednesday, my lord, because.
What will I do, sir? Without that report, I cannot decide this.
I leave it to the court.
Tell me something, whether any contribution had been made. No, contribution has been made. Very well, very well. Then you'll get the particulars. Madam, kindly disclose all particulars and bring in all records.
17 to.
Oh, I've said such reports should also disclose exact quantum of provident fund due and payable to the petitioner. Yes, yes.
She says that Wednesday, my lord, as a special case, my lord, if I can persuade your lordship to make a conscious departure, keeps it under the heading to be mentioned, let her file the report on Wednesday.
Wednesday next week. Next
He's saying next week. She's asking for a week's time. Advance copy to you next week. What will I do? Tell me.
I'd leave it.
No, without the report, can it be decided?
leave
It
it to
cannot
the
be.
court.
Then I have to call for the record. If you leave it to me also, I have to call for the records.
This matter is, my lord, before your lordship 4 occasions, and before the other
Court
court
can
at
only
least 10
direct.
occasions.
The court can only direct. And ultimately, if they do not come, then I'll direct them to personally
Next
present
Monday,
in court.
kindly keeps it if your lordship is
I'm in
not in
circuit.
circuit.
I'm in circuit. Up to now, I know that. I do not know. There's no notification. So if there is no notification, then I'll always place it.
Monday ki baat?
Monthly list, Mr. Bhattacharya. On the prayer of the learned on the prayer of the learned
One thing it is my duty to point out, there is a 2018 matter. The connected matter is a 2018 matter. I need to write to the Chief Justice, Honorable the Chief Justice, to get it assigned. Because 2017 matter, my lord, your lordship may take it up. 2018.
I'm just adjourning this matter. I'm not passing any order today. Madam, prepare your affidavit.
I'll take steps to get
You
it
take
assigned.
steps. Just adjourning this.
One take steps order should be there so that, my lord,
No, I cannot type that. It is for you to take
Very
steps. Oh, there's a 2018 matter. Then I have to detag it and release it.
2018 matter.
And that's why I'm not doing anything today.
Keeps it, my lord, as it is.
If you see, find out what happens then. Kichuna.
But it is understood, my lord, that she is going to hand over the affidavit, my lord, in course of this week.
না এটা নেক্সট মান্থলি লিস্ট করে দাও অর্ডার দিতে হবে না কোনো অর্ডার লিখতে হবে না নেক্সট মান্থ লিস্ট কোনো অর্ডার দেবে না
2017 matter may ordinarily come in the monthly list.
তুমি না এটাকে সব সময় দিয়ে নেক্সট মান্থলি লিস্ট করে দাও কোনো অর্ডার করছি না এমনি করে দাও check out on the next date. If there is nothing, then I will detag 18 and hear out 17.
Very good. And in the meantime, my lord, if I can get it, my lord, done.
Otherwise, I'll hear out 17, I'll detag 18 and I'll hear out 17. 17, I have determination. That is your matter.
Yes. 17 is the main map.
Yes, so I will hear out. You want it, I'll detag it today itself.
18 টা ডিটেক্ট করে দিলে তাহলে 18 এর ফাইলটা তুমি অ্যাসাইন করে নিতে পারো।
Let me detag it. Take it, file দিয়ে দাও নালে because I don't have determination. I don't have determination.
Now let the 2018 file may not be
Take it, ফাইলটা দাও আরেকবার ফাইলটা দাও
with liberty to take steps.
No.
হ্যাঁ কি বলছিস আজকেই চিঠি করছি যাবে তো ওখানে ফাইলটা যাবে
Where is the order directing both the matters to be heard together?
An initial order. I just can't assist your lordship here and now. And kindly keeps it blank, Miller. I'll find it out for your lordship. Miller, your lordship takes up the other matters. এবার দিয়ে দিন আমাকে কপি দিন
Mr. Bhattacharya, learned advocate representing the petitioner in WP, in both petitioners in both, representing the petitioner, submits then by an order dated
বলছে কৌশিক দা
1st February 2023, at the instance of the petitioner, this court, at the instance of the petitioner,
He did not take the.
Bhattacharya, Mr. Bhattacharya, learned advocate representing the petitioner, by drawing attention of this court to the order dated 1st February 2023, submits that at the instance of the petitioner, a coordinate bench of this court had directed both the writ applications being WPA 2645 of 2018 as also WPA 26730 of 2017 to appear for further consideration. To appear for further consideration. Full stop. It, however, appears that this court does not have determination insofar as does not have the determination to take up the matter being WPA 2645 of 2018. Full stop. Having regard to the aforesaid, let the writ application being WPA 2645 of 2018 go out of the list. Now, release to have na, should go out of the list.
Yes.
Go out of the list.
Other petition be.
Let WPA full stop. Paragraph. Full stop. Let full stop. Since the learned advocate, since Miss Sengupta, learned advocate, representing the respondent number 4, prays for an accommodation. Now, prays for an extension.
2018.
There is nothing is indicated. This is in 2018.
He is appearing in both the maps.
No, madam, no, what is it? He is not party in the both the matters. Provident Fund only the 2018 matters.
The other matter, Provident Fund, is not a party. Just a minute. ওই লাস্টেরটা লিখবেন না, ওই অবধি লিখুন। অর্ডারটা বলছিলাম কিন্তু ওয়েট করুন, দাঁড়ান, যদি না হয় ওটাকে দেবো না।
পরে অ্যাপিয়ার করেছে, অ্যাড করেছিল 2645।
Oh, Provident Fund Authority is not a party.
645.
Just a minute. 2017, they are not a party. So, এটা কোনো অর্ডারটা দেওয়ার দরকার নেই, লাস্ট পার্টটা। ওই যে 2645 of 2018 অর্ডারটা দেওয়ার দরকার নেই। ওটা হলো ব্যাস, তারপরে কিছু না। Well, list 26730 of 2017 in the monthly list of Mr. Bhattacharya, go through that order once. There is a direction. Okay, File that out. There is a sticker. I have it. You had made the submission at your instance. A coordinate bench had directed to appear together in the 3rd paragraph. So that is what I could find.
Yes, yes. That is the order.
So that is, there are no other orders, Mr. Bhattacharya. Previous assignment order is different. Thereafter, Justice Banerjee had taken it up, so I am considering it. দাঁড়া, এটা হয়ে যাক, হয়ে গেছে, সব হয়ে গেছে, শেষ হয়ে গেল, কেউ করবে না মামলা? Yes. So that is the order.
Yes.
Monthly item number 16.
Lordship, I am appearing on behalf of the respondent.
I have got the petition.
DG.
Yes, it. My lord, in this matter, my lord, I paid for some relevant records and documents. The charge against your lordship, I will come to the charge first. Page 70, annexure P6. This is the charge. Now your lordship kindly come to page 75.
Final order passed.
Final order passed. I paid for an appeal. Appeal was dismissed. Now first, my lord, submission. Lordship kindly see annexure P7, page 75. List of documents required. I asked for this.
What is the relevancy of these documents?
My lord, I am coming to that point. What is their answer? Page 76. On perusal of your representation, dated 6th May 2010, it is evident that the list of documents as demanded by you is not at all related with the
I've read that, yes.
draft charge framed by the undersigned. However, during DR inquiry, those documents which are related and necessary will be provided to your demand. This is their reply. Then again, my lord, I P9, page 77, I asked for the documents. I have given the relevancy of the documents. Page 77 and page 78. Now, my lord, what is their reply? Annexure P10, page 79. This is very important. Enquiry officer reply. On perusal of your representation dated 11/8/2010 in regard to supply of documents to face the DR proceeding, it is to inform that all the relied upon documents has already been supplied to you earlier. So, in question of other documents which you are likely essential to face the DR proceeding, in connection with the above charge sheet, level you advised to submit a representation to the senior DSC at Asansol to get the same. So, enquiry officer avoid his responsibility. He shift the burden to the higher authority. Now you will also kindly come to P11, page 80. Most humbly I beg submit before your honor that I am extremely sorry to say neither any exhibits as exhibited during DR inquiry, any relevant documents related to the charge sheet, even the documents sealed on the scissor list 1 and 2 have been supplied me by your good self during inquiry, which is much essential for me for making my defense statement. Therefore, you are requested that the exhibits as exhibited during cross-examination of PWs on various dates and documents placed under scissor list 1 and 2 may kindly be supplied to me as per GA and rules, and I am entitled to get the same. Now, lastly, kindly come next page, P12, page 81. During the course of inquiry into the above charge sheet, held by you, compliance of calling customer has come in the picture. As such, they have become prosecution witness for the purpose. They are required to examine, cross-examine. Their involvement and prosecution witness is under Shri V. Singh, Assistant Security Commissioner, Asansol. He has conducted preliminary inquiry into the case and submitted a report about the incident for which I have been charged seeking. P.K. Mukherjee, Senior Section Engineer, POA, and Junior Section Engineer,
they have submitted report after examination of sealed railway materials on being called by you of the Rampur post case number such and such. Shri S. Kundu, section engineer PUA, has also submitted report after examination of CST 9 plate sealed under serial list. As on being called by you of Sitampur post, dated such and such, refers to RPUP Act case as per the inquiry report submitted by you inside the court of learned judicial magistrate.
Why this matter was adjourned on the previous occasion? Why this matter was adjourned on the previous occasion?
Your lordship directed them to produce the record.
Produce the record. Yes, where are the record?
Records are with me. See.
Then your lordship kindly come to next page, page 82. What is the reply of the inquiry officer? Next at 30, second paragraph. Now, as per rule, you are giving opportunity to produce the name and full address of your defense witnesses and defense documents, etc. if any within 7 days. Very well. First, kindly come to page 314. I have given the name of the defense witnesses. My defense witnesses whom I want to produce for your examination are written below with their address. 1. Sri Hiralal Jadhav. 2. A.M. Kishku, Inspector RPF Post Sitampur. 3. Sri Vivek Patani, Shanti Nivas, Apartment. 4. Sri Sandeep Kumar, near Chittaranjan Railway Station. 5. Sri P. Chowdhury, Inspector CIB, Asansol. This DW will elucidate about my performance and integrity. What is their reply? P15. That's very important. Your request on the above issue by letter number such and such has been thoroughly examined, but the same cannot be acceded to as the charge as justified against you having no relevancy with such DWs, but is a matter to be considered by the Honorable Court in RPUP Act case number such and such.
Which is this case?
No reason. DW was denied. No reason.
Which is this case?
My lord.
RPUP case?
They know very well. They have produced the RPUP case. I have not.
This was initiated against those persons.
Therefore, keeping in view the provision contained in para 153.16 of RPF rules 1987, undersigned refuses to call any such DW or to allow further any document to be produced in evidence in this DR case. So the proceeding in the case is closed. DW will not be produced, closed. All these defense witnesses will prove the case. When your lordship can come, I have given written defense statement in my written defense.
Very well. Let me get from her what is her defense.
Hello?
Let me get from her what is her defense.
Lordship. Now, if it is related to the documents which were not supplied to the petitioner, reason was their lordship, the documents which he asked for was not related to the DR proceeding at all. That was related to the RPUP Act, for which, and at that point of time, those documents were subsidized under the additional district judicial magistrate Asansol, for which those documents cannot be, we cannot be able to provide to the petitioner, and that particular point was always mentioned to our every letter, that as the matter is already pending before the additional district magistrate.
Why did you proceed with the inquiry, madam?
Lordship, this inquiry proceeding.
What are the charges against him? Let us
Lordship,
go back. What are the charges? Article 1, page 70.
Yes, Lordship.
Place it.
BK Singh, Sub-Inspector RPF of CIB Asansol, in spite of being posted as Sub-Inspector RPF of CIB Asansol in Asansol Division since 21/04/2005, failed to collect any intelligence and failed to monitor the illegal activity of the firm Messrs. Hira Concas Limited, situated at Mouja, Nakra, Joyra on Dendua, Kolneshwari Road, PS Salalpur, District Bardhaman, West Bengal, near Sitarampur Railway Station in Asansol Division, receiving stolen railway iron materials in spite of the fact that the said firm was repeatedly searched by different unit of RPF of Asansol Division and by Sri VK Singh himself on 15/7/2008. He also failed to collect intelligence on presence of huge quantity of stolen railway iron materials in Messrs. Hira Concas Limited on 06/04/2010. Let alone search and recover though the team of CIB/HQS such the recovered different type of railway stolen iron materials valued of rupees 5,80,000 from the said firm Messrs. Hira Concas Limited on 06/04/2010 with arrest of one offender. Hence, Sri V.K. Singh, SIPF of CIB Asansol is charged for gross neglect of duty and violation of duty committing breach of Rule 146.2 subclause 1, 1471 and 1472 to be read with Rule 441.
Was any criminal case initiated on the basis of these allegations?
Yes, Lordship.
That is the RPUP case.
Yes, Lordship.
So how can it not be relevant, madam?
Lordship, though
Same case, same identical facts based on which you wanted to prove the charges, madam.
Lordship, yes, Lordship, but the case, the proceeding initiated against the petitioner was departmental proceeding for negligence of his duty, Lordship.
In connection with
In connection
that
with
same criminal charge?
Right, Lordship.
So why did you not make over these documents to him?
Lordship, that was not relevant to this particular.
Why it is not relevant? This is in connection with that stolen goods of Hira Concast.
Lordship, kindly come to the page 77. I will show you that what documents they wanted from us.
Yes, yes. Sure.
List of documents required. Lordship, there?
Yes.
Point 1. Copy of statement of the arrested persons, namely Sandeep Kumar in connection with RPF/post Sitarampur case number 01/2010 dated 07/04/2010 under section 3A RPUP Act. Lordship, why he need this statement of arrest? To prove his innocence or prove his disobedience towards his duty.
That is not relevant, madam, for you to consider whether the document was relevant for the inquiry or not. Whether that document would have ultimately helped him or not is different. But whether the document was relevant, had any connection with the inquiry. That was the issue.
At that point of time, inquiry officer did not feel that these documents, or he did not consider these documents to be relevant for the purpose of those the inquiry proceeding, Lordship. Therefore, he says it was not relevant to this proceeding and he refused to produce the same. And thereafter, Lordship, if
what about the witnesses?
Lordship, I'm coming to that, Lordship. Witnesses. Lordship, kindly come to P14, page 83.
Yes.
Lordship, I am instructed to submit before your Lordship that whenever a petitioner, whenever the charge official, if wanted to produce any of his defenses, they need to obtain a consent letter from the particular person.
It is reflected in your order that because the consent letter is not there.
No, it's not there. It is not there.
Why do not make that statement, madam? You're an advocate. You have to confine your submissions to not your client says, but what is there on the record. If the order does not reflect that, you cannot put up additional points.
Pardon, Lordship. Lordship, kindly come to the defense witnesses.
Yes.
One, Sri Hiralal Yadav. He is the person who was arrested from that day when the stolen property of the railway.
Was he in police custody at that stage?
Yes, Lordship.
So you could not have produced.
Lordship.
Very well. Fair enough.
Lordship,
second witness.
Second witness, Sri A.M. Kisku Inspector. He was the parts in charge of the Sitaram post under whom jurisdiction the railway property was seized. And he also was charge sheeted from the same particular.
Maybe. What was he arrested?
No, Lordship. He was not arrested.
Then why was he not produced?
Lordship, in this particular proceeding, Lordship, he was also charge sheeted from the same cause of action, Lordship.
Maybe. But he was a relevant witness. Same cause of action, as you say. So he was a relevant witness.
Lordship, as I have instructed, I rely on that, Lordship. That.
Where is your affidavit? Did you file any affidavit?
Lordship, I have filed my affidavit.
You say the defense witness has no relevancy,
Yes, Your Lordship.
but you say is based on the same cause of action, a departmental proceedings was initiated against him.
Ask for clarification whether why they did not after first occasion, Lordship, when you have heard and asked me to produce the records, I asked them for clarification why they did not provide these witnesses, why they did not allow these witnesses for the purpose of proceeding. Then they categorically informed me without supporting any documents, Lordship. They categorically informed me that the first one, he was arrested at that point of time when the railway article was
Very well.
made.
That is,
And-
you cannot direct him to be produced because he was in custody.
Lordship.
What about the other two witnesses?
Other witness, Lordship. And the third one is also the person related to Hira Conquest, and he was also arrested, Lordship. He was under the trial proceeding before the additional.
Where are the documents in support of your contention that he was under arrest at that point of time?
Lordship, I am with the DR proceeding documents. I do not have RPUPR documents, Lordship.
No, you bring all documents, madam.
Lordship, just let me go through with the documents.
Yes.
We'll find some.
Find out.
Lordship.
I have heard Mr. Mojumdar on the last occasion. These were the queries. So once he refreshed me, I now remember the facts. Now the question is, you see, in this case, he has not been given appropriate opportunity to defend.
Lordship.
How can he sustain? Documents were not supplied.
Lordship.
Witness were not permitted to be produced. What more? How will you prove your innocence, madam? Opportunity has to be given. You might consider that the person is guilty. You might consider. But you are holding an inquiry. You are not passing a judgment. So in the inquiry, reasonable opportunity has to be given. A, that he has to be given access to all documents which are relevant. He is asking for these documents, and these documents are not such documents which have no connection with the case.
Lordship,
The,
here,
the effect is the failure of the inquiry, madam. That
Lordship,
is the effect. How old are you? Sir, petitioner, how old are you? Reached the age of superannuation?
Service, he's still.
Still in service. How many years left?
But when this case.
Hmm.
He has already retired from service.
Lordship, I want to rely upon one particular rule, Lordship.
I will hear you.
153 of 16.
Yes, show me. Dakao. RPF বই দাও। That is, if he refuses to produce witness, he has asked you
And
to.
there is another point, Lordship. Let me
Yes.
come to the third line of that point, Lordship. If the inquiry officer considers that the evidence of any witnesses or any documents which the party
Is not
charged-
material.
Lordship.
Is not material. Question is that whether the witness or the documents he is seeking for, is it material or is it not material? Now, is it now in judicial review also I can consider whether by reasons of denial of this document he has been wronged in a sense he has been denied opportunity to appropriately defend himself. Any authorities?
Authorities are not here today, Lordship. I can make a call so that I can get that confirmation whether they are available here or not.
Where is your RPFC case
Lordship,
records?
RPUP case. Lordship, it is here with me.
Show me that. You have already reached the age of superannuation.
Yes.
What remains? And what was the punishment inflicted on you?
Was punished with
Dismissal.
no, Lordship.
Then
He was demoted for 2 years. And thereafter he went for appellate authority, and that point of time his punishment was reduced by 1 year. So that he was getting punishment for one particular year, Lordship.
but unfortunately, if you have not permitted him to defend him at all, then what remains in the matter? Why did you close the evidence, madam?
Lordship,
You could have said that any other witness you want, you produce.
Lordship,
You simply sit and closed it.
I asked for that clarification. They would have relied upon only in this portion, Lordship, that
He did not say that I will not produce any other witness also.
Lordship, he did not.
But you closed it.
We could have
You were
given
in a hurry
Lordship,
to conclude the proceedings.
no, Lordship, as
No.
we went that time, that particular time, inquiry officer was on hurry, Lordship, but the point is that he was keep asking for the same documents which the department has already refused to provide.
Assuming I accept your content, no. The inquiry office department may refuse to make over several documents to him. But the question is whether the inquiry they were relevant or not.
Lordship, those
They
documents,
were related to the same cause of action.
Lordship.
Or are you denying that?
No, I'm not denying that, Lordship.
So if it is related to the same cause of action, was he not entitled to a copy of that?
For some documents, Lordship, some documents are related to that same cause of action.
Which
but not
document? Identify.
Lordship.
Page 75.
75, yes, Lordship. Okay. Lordship, first statement is copy of statement of the arrested persons, namely Sandeep Kumar, in connection with RPF post Sitarampur case such and such. Lordship. Second is that copy of post diary of Sitarampur post made by IPF STN dated 6/4/2010 after returning from raid or such jointly with HQ/CIB from Hira Concrast /
Actually, he may be involved here. What was said against him?
it was contended that he could not able to recover any stolen material.
Whether anyone made any allegation against him. That was the incident he wanted to know from this. Then copy of the theft report.
Lordship.
Yes, charge is one arrested, person was arrested. Charge against me that materials were recovered with arrest of one offender from the, so certainly.
Lordship, that.
Who was arrested?
Lordship.
Who was arrested?
Name of the person was not given.
Madam, who was arrested?
Lordship, Lordship.
Is it Sandeep Kumar?
Lordship.
He was the person who was arrested.
Sandeep Kumar was arrested, Lordship, yes.
In connection with, come to articles of charge number 1.
Lordship.
No, not articles of charge number 1.
Lordship, kindly come to Article 2 once.
Mr. Mojindar, where is that charge that one person was arrested?
Kindly come to charge 1.
Yes.
Last line.
With arrest of one offender.
Yes.
Who was the offender?
Lordship. Lordship. Lordship, yes, this Shandip Kumar was arrested at that.
Then the statement of Sandeep Kumar was necessary. Yes, you want to add any other thing, anything else?
This was my
Best case.
encrypted submission, Lordship. This is what I get from the department. Whenever I ask them for explanation, they explain me with.
What do you want, Mr. Majumdar?
Let the punishment be quashed.
Lordship, there is nothing.
And my
what
original scale of pay be restored.
at this point of time that has been restored.
Not only that,
I have to take
findings,
instruction on that.
erroneous
point.
findings of the incorruption as well as the findings of the disciplinary authority.
Instruction is not necessary. I am not asking, it is not dependent on you.
Lordship.
You understand this,
Yes, I am understanding.
what will happen in the matter.
Yes,
You want
sir.
to show me any authorities?
Lordship,
Natural justice has been violated.
Prejudice has also been caused to him. Let me conclude.
Lordship, if you Lordship direct me so I can produce any of the official by now if they are available right now.
What more, madam? You have brought in the records, they are there.
Records, all records are there, Lordship.
Record is to assist the court through you so that you can go through that.
Lordship.
Put a page mark on that particular page where Sandeep was, what is his name?
Sandeep Kumar.
Sandeep Kumar was arrested. And what is the case number?
Lordship, case number. Lordship. STN 01 of 2010.
Yes.
CR 346 of 2010 before Learned ACGM Asansol.
No, that is, he was arrested in a police case.
Lordship.
What is the police case?
Lordship, the RPUP Act case, Lordship. He has been arrested in the RPUP Act case, Lordship. And this is the case number, CR 346 of 2010. Yes, Your Lordship.
No, that is after being converted. He was arrested in a police case, madam.
Lordship. There is no separate police case has been lodged by.
An FIR is there on the basis of police case, an arrest is made.
Lordship. No other cases, Lordship. This is the only case number they have provided in the.
Final order, Mr. Majumdar, final order.
Lordship, can we come to final order? That is case 113 under the penultimate portion of the order. Hundred 16 and 17.
Reverting to the rank of assistant sub-inspector.
Yes.
You prefer an appeal?
I prefer an appeal. Lordship, can you see the order of appellate authority?
Yes. 121, 13th October.
Yes. Appellate authority, my lord.
He did not take into consideration this aspect?
No, nothing.
Where did you raise this question? Violation of principles of natural justice before the appellate authority?
Lordship, can you come to my appeal?
Yes.
My appeal page 110.
Yes, I have seen that. 120. Did he decide this issue?
Nothing. Yes,
Did the appeal court address this?
I have addressed, yes. Lordship, I have.
You have addressed it. Did the appeal court address this issue? Madam, did the appeal court address this? Did not consider this at all
No,
He
Lordship.
in his order?
Lordship, appeal court didn't find that there's any violation of.
That is different. So where is that line? The appeal court did not find there is any violation. Where is that line?
Lordship, kindly come to the page 123, Lordship. Third paragraph.
I have gone through the appeal. Lordship, kindly.
I have gone through the appeal, parawise comments and
I have
other
gone through the
relevant.
appeal. Parawise comments and other relevant papers in the DR case file.
Yes, and then he sets out this. These are the contentions. Yes.
On Ato, a team of CIB headquarters conducted search in the premises of Mesa Sierra Constability and recovered different types of stolen railway materials, value rupees search with arrest of one outsider. Shri V.B. Singh, important, Shri V.B. Singh, Assistant Security Commissioner, RPF Asansol, was nominated by Senior PSC Asansol to cause preliminary inquiry. Since he did not hold any RPM member responsible, the preliminary inquiry report was ignored because he did not hold any responsible to any RPF officer. Ignored. And Shri M.N. Thakur, ASC RPF, was entrusted with the same work with an instruction to complete the same epic assessment.
No, madam, just a minute. Madam, there is nothing with regard to violation of principles of natural justice.
No, Lordship. I was going to read it out, Lordship.
Yes.
Kindly come to the page number 124, Lordship.
Yes.
On going through the available records and the statement of the above personnel, it is very much clear that huge quantity of railway material was it.
Fair enough. With the line, particular line.
It is concluded that the above officials have been failed to detect due to lack of.
Which page you are reading?
Lordship, 124.
Yes. Yes.
Lordship, kindly come to the second last paragraph.
Yes.
Thus, it is clearly seen that the V.V. Singh, the then AC/ASN, had also held 04 subordinate officer, including the appellant, guilty of the lapses based on which they were issued major penalty charge sheeted. The disciplinary authority has said in his parawise comments that Shri M.K. Thakur was also asked to inquire further into the case as Shri V.V. Singh had left as a.
So come to the 6 issues. 6 issues mentioned below. First, biasness, forget it.
Yes.
Now he wanted to produce, appellant wanted to produce those persons as witness.
Who were either accused in RPUP Act case registered by the RPF or their representative.
Yes.
So therefore it was denied.
Where is that line there for which you are adding?
No,
that sentence
no,
that you are submitting, madam, where is that line?
That line is not mentioned over here.
That is your submission.
What are the reasons, Lordship?
Where is that reason? Where is that reason which you just submitted that this is a reason? Where is that reason recorded in the order?
Not recorded over here, Lordship.
Then, madam, he did not decide this issue at all.
Lordship.
Then he said that you can get it by Right to Information Act.
No,
It is there, you take it.
No, Your Lordship.
What is this? Ashok. The present writ petition has been filed inter alia, challenging the charge sheet dated 3rd June 2010, comma, the findings of the inquiry officer dated 31st of March 2011, 31st of March 2011, comma, the second show cause notice dated 5th April 2011, the final order dated 30th April 2011, and the order passed by the appellate authority dated 30th September 2011. The petitioner claims to be a the petitioner was a sub-inspector of Railway Protection Force. Claims no. Petitioner was a sub-inspector of the Railway Protection Force of Eastern Railways and at the material point of time was posted at RPF CIB unit Asansol. Post up. while being so posted, comma, by an order dated 7th April 2010, passed by the Divisional Security Commissioner, comma, RPF, comma, Eastern Railways, and in terms of the Eastern Railways, the petitioner was placed under suspension in contemplation of a departmental proceedings. Paragraph. According to the petitioner, the said order of suspension dated. According to the petitioner, the said order of suspension was subsequently revoked and the petitioner was reinstated in service. Later, he was served with a copy of a charge sheet dated 2nd May 2010 issued 2010 according to the petitioner 2010. According to the petitioner, the respondents while issuing the charge sheet had already made up its mind to hold a disciplinary proceedings, hold a major penalty disciplinary proceedings in terms of Rule 153. In terms of Rule 153 of the Railway Protection Force Rules 1987, hereinafter referred to as the said rules. The petitioner contends that the inquiry proceedings were conducted in an irregular manner despite the petitioner repeatedly calling upon the respondents to make available copies of relevant documents. The same were not supplied. Initially on the pretext, the same were not the same were not supplied. Stop. The respondents did not stop there. No, a line to get the respondents did not stop. In fact, when the petitioner when called upon by the inquiry officer by communication in writing dated 17 November 2010, had by his letter dated 24th of November 2010, had requested the inquiry officer না এটা তো রিকল, এটা না। This is recall, sir. Mr. Mojumdar, this is recall of witness. This is recall of witness.
Defense witnesses.
Where defense witness? This is recall.
No, no. Annexure P14. Page 83. My defense witnesses, whom I want to produce. for the
Very
defense.
আচ্ছা আচ্ছা লাইনটা আছে আচ্ছা। To ensure production of 5 several persons attached with the respondents as defendant witness such request was turned down. Such request was not only turned down, but the evidence action, but the witness action of the petitioner was also declared to be closed. Mr. Mojumdar, learned advocate representing the petitioner, submits that on the basis of irregularity, submits that the inquiry officer, without following due procedure, had concluded the inquiry. The disciplinary authority did not take into consideration the representations made by the petitioner and had passed a final order dated 30th April 2011 holding that the charges in the inquiry having been proved, holding, no, and having held that the charges in the inquiry by an order dated এত কি বলে 30th 11 2011 and imposed a penalty of reverting the petitioner to the rank of assistant sub-inspector for a period of 2 years with cumulative effect, and the suspension period to be treated with cumulative effect, and the suspension period to be treated as suspension. Although the petitioner had preferred an appeal, the appellate authority did not take into consideration the issues raised by the petitioner in the grounds, the issues raised by the petitioner, the grounds on which the such appeal had been filed, and had mechanically, by an order dated 13th October 20, no, order dated 30th September 2011 was inter alia please to comma, while agreeing with the findings of the inquiry officer and the opinion of the disciplinary authority, reduce the penalty imposed on the petitioner from 2 years to 1 year without any modification in the nature of penalty imposed. Being agreed, the present data application is. Ms. Sarkar, learned advocate representing the respondents, on the other hand, submits that the petitioner was given all opportunities to defend by drawing attention to the copy of the charge sheet dated 30th June 2010. It is submitted that along with the charge sheet, which was issued in terms of Rule 153 of the said rules, the petitioner was supplied with the statement of allegations with the articles of charge in Annexure 1, the statement of allegations in Annexure 2, and the list of witnesses and the list of documents in Annexures 3 and 4 respectively. All documents which formed part of the aforesaid charge sheet were made over to the petitioner. Full stop. Since the petitioner wanted additional documents which according to the inquiry officer were not relevant for the purpose of the inquiry, the same was declined. However, at the same time, the inquiry officer, by his communication in writing dated 11th August 2010, had also stated advised the petitioner to make appropriate representation to the disciplinary authority. Since the petitioner did not make any such representation, did you make any representation? No. Disciplinary
When
authority.
inquiry started, I have no right to
You
make
can
it.
actually, I'm just asking you.
Because I made a representation to the inquiry officer.
Since the petitioner did not make any further representation, no further documents were made available to him. The respondents cannot be faulted, full stop here. The respondents cannot be faulted. The inquiry officer cannot be faulted for not making available documents which did not form part of the charge sheet. That is your contention, madam? Full stop. Insofar as refusal on the part, alleged refusal on the part of the inquiry officer to allow production of defense witness, it is submitted that all the aforesaid witnesses which were called for by the petitioner were involved in RPUP Act case number 1 of 2010, dated 6th April 2010. Madam, kindly hear, this is your submission. 6th April 2010, and as such, they were the inquiry officer having the inquiry officer cannot be faulted for declining to make available the aforesaid persons as defense witnesses. Anything else? So, by drawing attention of this court to the appellate order, it is submitted that the appellate authority, taking note of the submissions made by the petitioner, and reduced the punishment. First up, in view thereof, no interference is called for. Has already reduced the punishment, and in view thereof, no interference is called for. Anything else, madam? Heard the learned advocates appearing for the respective parties and considered the materials on record. Admittedly, in this case, it is noticed that a charge sheet dated. Admittedly, in this case, it is noticed that a charge sheet dated ওই আছে না ডেটটা dated 2nd May 2010 was issued. The articles of charges leveled against the petitioner are extracted below. শুধু articles of charge, page number 57 এ আছে। হ্যাঁ, extracted below। এখান থেকে পুরো মাথা থেকে শেষ অব্দি এটা একেবারে এইটা বাদ দিতে পারেন, এই অবধি দিলেই হবে, এই অবধি এখান থেকে পুরো উপর থেকে extracted below. So records reveal that immediately upon receipt of the aforesaid charge sheet, the petitioner had টাইপ কপিটা পরের পাতায় আছে, আপনি অরিজিনালটাকে ছাপবেন, হ্যাঁ টাইপ কপিতে ছাপবেন, এটা আছে 57 is the charge sheet, 57 page 57 charge sheet. Immediately upon receipt of the aforesaid charge sheet, the petitioner by a communication in writing dated 17th of May 2010, while denying all allegations, বলেছি had denied all the allegations. Subsequently, by a communication dated 11th August 2010, had requested the inquiry officer to supply the petitioner copies of relevant records and documents for the purpose of effectively defending the case. Effectively defending the case. The list of documents ডেট বলেছি না, আগের লাইনটা কি বললাম, সরি তার আগে কি বললাম লাস্ট টাইম, while denying the denied all allegations, full stop, or denied all allegations, full stop, তারপর একটা লাইন ঢোকান, না কাটবেন না, লাইন ঢোকান। Following the same, by a letter dated 6th of May 2010, the petitioner had called upon the disciplinary authority to favor the petitioner with a list of documents for the petitioner to effectively respond to the charges. Full stop. The list of documents as sought for by the petitioner by communication dated 6 May 2010 is extracted here in below, page 75, list of documents টা আছে পুরোটা 75, ঠিক আছে। সাবসিকুয়েন্টলি ওই কথাটা আছে, যেটা আছে দেখুন সাবসিকুয়েন্টলি বলা আছে, full stop. হ্যাঁ, in response to the same, না records however reveal that by a communication in writing dated 11th August 2010, the Assistant Security Commissioner refused to make available the documents sought for by the petitioner inter alia on the ground that the same had not been relied on in the charge sheet. It is in the circumstances as suppose that the petitioner had requested the inquiry officer. No, দরকার নেই। Records, however, records also reveal that by communication dated 17th, that by communication dated 17 November 2010, the inquiry officer had called upon the petitioner and afforded an opportunity to the petitioner to produce the name and full address of the defense witnesses and the defense documents. Full stop. In response to the same, by a communication in writing dated 24th November 2010, the petitioner had called upon the respondents to permit the petitioner to produce 5 several witnesses who were in the employment of the respondents. Full stop. Who are in the employment of the respondents. It however appears that by a communication in writing dated 9th December 2010, the respondents had refused to permit the petitioner had informed the petitioner by communication dated 9th December 2010, had informed the petitioner that it was not possible for the inquiry officer to accede to the request made by the petitioner, as the defense witnesses were all part of the proceedings pending in RP within bracket UP Act case number 1 of 2010. Full stop. By the self same letter, the respondents further directed that the proceedings, that the witness action insofar as the petitioner is concerned was treated to be closed. Full stop. It may be relevant to note that in the charge sheet, it was specifically stated that from the charge sheet it would appear, relevant to note that from the charge sheet it would appear that in connection with alleged theft of railway iron materials by Messrs. Hira Concast on 6th of April 2010, one offender was arrested. Miss Sarkar, upon going through the records, by placing reliance on the records, has confirmed that the name of the offender is what is the name of the offender? Ki bollo? Sandip Kumar. I find that one of the documents sought for by the petitioner was the copy of statement of the arrested person Sandip Kumar. Having regard to the aforesaid, I am of the view that the document sought for by the petitioner cannot be said to be irrelevant for the purpose of holding and the inquiry proceedings. Although Ms. Sarkar has strenuously argued that the inquiry proceedings, that the defense witnesses being involved in RPUP case, RPUP Act case number 1 of 2010 could not be produced now, although has কি বলেছো? UP case and Act case of 2010 and being involved in a separate inquiry proceedings would not be produced. I am of the view that the same cannot constitute cogent grounds for the inquiry officer to refuse production of witnesses, defense witnesses, nor could the inquiry officer straight away close the witness action of the petitioner by his communication in writing dated 9th December 2010 without affording the petitioner a further opportunity. Question. Although the petitioner had duly made a representation to the findings of the inquiry officer, the same appears to have been findings of the inquiry officer. The same appears to have been overlooked by the disciplinary authority, and the disciplinary authority, on the basis of the inquiry conducted by the inquiry officer, had imposed a penalty. Inquiry officer, and having held that the charges established, charges leveled against the petitioner stood established, had imposed a penalty of reverting established, had imposed a penalty of reverting the petitioner to the rank of assistant inspector for a period of 2 years with cumulative effect, and the suspension period to be treated as suspension. Full stop. I find that although the petitioner had preferred an appeal, I find that the petitioner had duly preferred an appeal and had raised several grounds. Unfortunately, the appellate authority, by his order dated 13th October 2010, had brushed aside the same, and by a mechanical order, and brushed aside the same, and by his order dated 30th September 2011, while recording that he did not find any reason to disagree with the findings of the inquiry officer and the opinions of the disciplinary authority, had reduced the period of penalty from 2 years to 1 year without any modification in the nature of penalty imposed. From a perusal of the aforesaid order, it would appear that reduction of penalty was more of a concession given to the petitioner for the petitioner not being able to appropriately defend the case, although no such reflection is found in the said order. Having regard to the aforesaid, and taking note of the fact that the petitioner was not only denied relevant documents, not only denied inspection or copies of relevant documents, but was denied the opportunity to place defense witness, I am of the view that the final order passed by the disciplinary authority cannot be sustained. The same is accordingly set aside as a sequel date to the order passed by the appellate authority is also set aside. With the above observations and directions, set aside. The petitioner shall be entitled to all consequential benefits. With the above observation and directions, the writ application sends is post off.
Your Lordship.
পেন ড্রাইভে করে দিয়ে দেবে, হ্যাঁ, হাতে পাতা নষ্ট হবে, কারেকশন
Monthly list item number 19.
But I have got the petition.
19 উন্নত কত 11,728 দেখো তো 17,000
My lord, an employment notice was issued for appointment of a contractual basis in the judgeship of Purva Mednipur Holdia Court, or the court was established. Different categories was published. Following the rule, regular recruitment rule, by conducting written test, viva, and selection committee will be selected. Thereafter, petitioner was appointed as contractual basis for 1 year. In the year of 2004, September 2004. Thereafter, to September 2005, a department has been issued a notification for regularization of contractual employees.
Which department?
Finance department. State government of West Bengal Finance department, who are the contractual appointment was given, they are brought under the regular establishment scheme. Accordingly, we applied for, though it is maybe automatically, but it is not done. I have made an application that was not considered. On several representation given to the Purva Mednipur district judge to furnish the document of that employees, but that was not furnished. Ultimately, in the year of 2007, a separate notification was issued for fill up the separate vacancy. There was fulfill the or another different category has been vacant. That was notified. In that time, I filed an application, writ application, not to fill up this post, which is the already sanctioned post. We are doing job as contractual basis till that date. Though there is a regular notification scheme, I have not till that. I have not regularized. My seniority not has been counted. In that writ petition, state government has said that this is a sanctioned post. No status code has not been continued, because if it is status quo be maintained, others posts will not be fill up. Though there the state government has said that this is a sanctioned post, so except this post, other post will be fill up. Thereafter, they said that their regularization will be done by very soon, and they took in time 2 months. 2 months has been elapsed. Nothing regular, no regularization has been come. Ultimately, 26 September 2011, noting this writ petition number, they regularized this petitioner from the date of issuing this order, that is 26 September 2011. But no reason has been given 2004 from the appointment or initiating my appointment till September 2011. But what purpose, what reason this period has not been calculated as my senior, this period has not been regularized, that has not been given in this notification. My humble prayer before your honor, that I may be regularized and my seniority may be counted from the date of at least issuing of the notification, from the date of issuing the regular establishment scheme when in the year of 2005. This is my humble request.
Date of notification, you have been granted seniority.
Yes, my lord. Date of when.
What are you asking? What are
I'm
you
asking for my regularity may be counted, or my seniority may be counted from the date of when the state government has notified for the purpose of regularizes the contractual appointment.
Where is that?
That is page number 48. Previous page was illegible, that's why it was typed 48. So we are appointed conducting the written test and viva voce and selection committee was made. That the following the regular recruitment process. 48. For the same time past, the state government has been following the policy of filling up non-PSC, non-promotional post or contract basis general for the 1 year initially with the approval of the appointing committee of the cabinet. In such individual cases, the contract appointment of these employees are also being renewed from time to time. Since, however, the job attached to this post are perennial in nature, the above policy, kindly note, the perennial in nature, the above policy has been reviewed. On the basis of review, the governor has pleased to decide as under. Social post the general, any may be filled up on regular basis with the approval of finance department and the ACC of for this purpose, the steps should be taken for filling up the vacant post following the usual rule and method recruitment for the post. I skip over the second matter. 2. The governor has been further pleased to decide that the employees who were initially recruited on contract basis following the norms, rules and method as applicable to the relevant post may, if still continued contract basis, a contract service be brought under the regular establishment, subject to the above principle against regular vacancy in which they have been initially appointed with the approval of ACC. Contractual consultation with the finance department will be necessary in the such cases. In 83 is the order of writ petition. They stated that this is a sanction post, and they says that it will be regularized by within 2 months in the year 2007. Lordship got my lord 83. Order dated 14/6/2007. I am continuing service from 2004 without any interruption. So already sanctioned post, and only decision with regard to the five petition has to be taken. He assured this court that the petitioner will not be disturbed. In view of that order such and such, opportunity should be given to the state government to take final decision in accordance with law. Accordingly, the matter shall appear after 2 months. After 85, 14 September 2011, the petitioner was regularized. But no reason has been given.
Where is this letter? Of 2007?
2007.
Employment notice 1 of 2007. Take it 2nd March 2007. Where is that? 2007. Page 78. So your cause of action is from the date of at least, if not anything else, from page 78. From the date of issuance of the notice. Before that, you did not come to court.
When I
come to court prior to 2007, did you appear before the court?
No, 2007 when the notification was issued. Before that, I made several representation to regularize our service as regular.
Did you approach this
No, my
court?
I am not approached before
2007, you approached the court?
Yes, my lord.
So your cause of action can at best be from 2007 with regard to seniority?
No, my lord. My cause of action.
Because they said, the state government said that they are going to take a decision in the matter.
Yes, but finance department several representation has given to the district judge to furnish their document for their regularization. That notification That letter has been given by the state government department, my lord. I made prayer after 20,
Previously, there was an interim order, of status quo.
My,
That is also 2007.
my lord, regularization of the contractual employee, it should be automatically, because department has issued notice that the who are appointed as regular contractual basis, they will come under the establishment.
Correct.
regular
But
scheme.
after all, after that, the
If
notice was
department-
issued in the year 2007.
If department will do his own motion,
So
I have not.
why were you waiting between 2005 to 2007? Why were you waiting?
The department is issuing the letter and process were continuing. But in the meantime, whether notification, whether separate notification has been for the purpose of another, they accepted that they others posts are not disturbed with the post of my petitioner. They accepted that this is the sanctioned post. This post will not fill up, others post will be fill up. And my seniority should count from the date of notification when the government has itself issued a notice that all contractual employees will come under regular establishment scheme, though they are regularly without interruption here servicing, without they are continuing the service from the date of initiation of appointment.
That you are getting in the year 2007 and what remuneration you started getting in the year 2011? Was it the same?
No, my seniority has not been.
Is the same remuneration you are getting? Answer me this question. It's a query from the court. What remuneration were you getting in the year 2007 when you filed the previous writ application, and what remuneration did you start getting consequent upon your regularization?
That's that I have to, but the pay scale is 42 in my joining letter. Pay scale is 42, my lords. In my joining letter, they said there's a pay scale.
Oh. So there is no difficulty.
Yes.
Only seniority. What will you gain with the seniority?
Well, senior benefit will be.
Well, tell me the benefit. What is the benefit?
If I say become senior, the I got my promotion, that my service benefit increment may be increased. Service for the purpose of service benefit, I will get for the from the seniority. Seniority
You will get cash benefits.
Cash benefit and promotional also.
If you get promotion, you will not get cash. Either you get cash or promotion.
Yes, sir.
Is there any scope of career advancement scheme there that you are asking for seniority?
Advancement scheme.
No, you don't know.
I
what benefit you will get? Tell me. You want seniority very well. What special status will you enjoy by becoming senior?
Now I am posting lower divisional clerk. If I get seniority, my service benefit, my promotional benefit, and also the.
How many years of service entitles you to become?
Now I am more than 7 years I am servicing from 2004.
So you are not aware what benefit you will get. Did they decide this issue ever? Wait, I'll come to you.
They decided.
Did they decide this issue ever?
My lord, 85, 14 February 2011. I am directed by order of the governor to say that governor has been pleased to accord sanction to the regularization of contractual service of the following 9 employees of different categories attached to the subdivisional court in Haldia in Jalsi, Purva Mendipur, Sasensas Public. The order of the regularization of the above named 9 employees, the different categories will take effect from the date of issuance of this order, that is 2011, September 2011. Thereafter, the above named employee will remain in contractual service as usual on the day before the date of issue of this order of regularization. But no reason has been given for what purpose, by what reason he has been given contractual. Why my regular generality or regularization has not been count from the date of issuance of the regularization scheme. Though state government itself issued a notice that who are the contractual, they come under the regular establishment scheme. Though it should be automatically, but my representation was given, that representation was considered, but state government issued several notice to the district judge, but district judge has not furnished any document. That's why my regularization has not done at that time. Thereafter, a notification in the year of 2007 has been filed for the fill up another post. There, the state government has, this is a sanction post.
So what is the failure on the part of the state government?
If they did regularization from the date of regularization, when the regularization scheme has been
You
come,
say that the district judge did not furnish information.
that this is their from the letter it is given, my lord.
Did the respondent file opposition?
86, sorry, my lord, 68, my lord.
Yes.
With regularization of the contractual service of the employee of the different category attached to the subdivisional court of Haldia at Haldia. 68. With reference to the this deputy letter dated such and such 1666 and subsequent reminder dated 10/8/2006 on the subject above, I am once again directed to request you to furnish the particular document as sought for under above mentioned letter to
Did
this
you apply
department.
in any application before regularization?
Yes.
What application did you file?
For our regularization, when the regularization scheme has been published.
When did you apply? Where is your application?
My application is, my lord, #51.
This is your representation, sir. Where is
Yes,
your
yes,
application? Did you apply in any specified format?
There is no specific format application in research format. Only my representation has given. Our representation, we all are given representation to the district judge Purva Medinipur. On that basis, they acted and furnished the document. In this representation, on the basis of this representation, the deputy secretary requested the Purva Medinipur district judge to furnish the document for their regularization. They entertained this representation, but they did not final. They did not come under the finalize.
Anything else?
Anything else, my lord? Year 1999, Supreme Court 44. My appointment seniority and regulation should be counted from the date of initiation of my office setting, or the regular rule has been come. There is also another judgment, my lord, from 14, paragraph 14 onwards, my lord. There is another judgment also that has not presently I have not brought, but 2007-15 SCC 230 2007-15 SCC 230, paragraph number 10 and 11.
Page
230.
Paragraph
10 and 11, particularly 11.
And in this judgment, paragraphs
11. 10 and 11. Regularization should be given from the issuing notice of the regularization, issuing rule of the notification.
two three zero.
Yes. 230.
Or 238.
230. 2007-15 SCC 230.
Nothing is there. 2007-15 SCC.
Yes, 15 SCC. 15.
Yes.
230 page.
Sheila Rani.
Union of India, Sheila Rani. Yes, ma'am.
You are relying on this judgment.
Yes, ma'am.
Read paragraphs 8, 9.
8, 9.
Yes.
I am relying 11, ma'am. 8, 9 I am reading.
Yes, place 11.
The Registrar General of India versus V. Tipa Sethi, the tribunal's direction was to regularize the respondent with effect the date of promulgation of the recruitment rule or from the date of their appointment depending on the seniority list. In pursuance of the said direction on the new recruitment rule being promulgated on 11/5/85, the regularization was given effect from that date. However, in the subsequent order passed by the tribunal on 19/2/93, the tribunal has directed that they should be treated as having been conferred regular status with effect from 5/2/81, that is the date of their entry into service as investigators. This court held that the employees had entered as ad hoc appointees, and the question was whether they should be regularized in service since they had worked as ad hoc employees for a sufficient long time. If the ad hoc service is regularized from the back date in this matter, it will disturb the seniority of regularly appointed employees in the cadre, and therefore ordinarily the regularization must take an effect prospectively, not retrospectively. This court ordered that care must be taken to see that regularization does not upset the seniority of regulatory appointment, whether they qualify in a given case or not, or relevant, but there is relevant in that regulation should be prospective, not retrospective, as the chance of their upsetting the seniority cannot be overlooked. Though there is a rule, issued by the government for regularization. My respectful submission before your honor that the this should be seniority and regularity should be given from the date of issuing the order when the regular establishment scheme has been come. And they itself said that they who are the ad hoc basis and contractual basis of service, they should come under the regular establishment scheme. My responsible submission before you, Honor, that I may be entitled to get seniority and regularity from the date of issuance of the order rule in the year 2005. Yes, ma'am.
That is all.
Accordingly, following on the several employees, and other allowances give back of the skill footage against this each as and from 14 to 1. However, the above named as usual on the 40-day of issue of the order. As per the direction of the government from the state, the amount of
Now you want to fall back on Uma Devi.
Uma Devi is
You have regularized.
10 years continuous service.
You have regularized.
Already we have regularized.
Regularization is over. What will you rely on Uma Devi for what purpose? This is not a backdoor entry A.
In connection with the contractual employees, regulars and who have claimed the declaration contract of the date of their appointment in the contractual service.
Sir, what prevented you from 2007 to regularize them? Sir, tell me this. What prevented you from 2007 to regularize them? I appreciate 2004-5 is not necessary. They were contractual. 2005, you had a circular in place. 2007, you appeared before the court and said, we are taking a decision in the matter. And you attempted to bypass the whole procedure and appoint third parties by ignoring them. The court granted an order of status quo. Why shall you not be directed to granted a status quo? That was the subject matter of writ petition. There, sir, understand, Mr. Ghosh, there was a status quo. Now the court permitted that and said, you said before the court, I will not disturb. You said that the state government is taking a decision on the basis of that. So you do not pass any order. And 8, 9, 10, 11, it took 4 years for you to take a decision. Yes. Why will he suffer? Why will he suffer? Seniority displacement. You had invited those applications. So I will not permit him to tinker with the seniority. So apart from this gentleman, others were appointed. So he should be treated as par with. So naturally, where are the particulars? Yes, who were appointed. What is his seniority vis-a-vis your employment notice dated 2nd of March 2007? Sir, that is the moot question to be considered. He has also showed that judgment, second judgment, where he has said he did not distinguish it, but the fact remains. The question is whether he tinkers with the seniority. So that part, yes, that part should not be permitted. But here the court had interjected and court had said his, you see, seniority was the moment the court passed that order and held that you regularize, we were obliged to take into consideration this aspect. Yes. Page 83.
83.
Mr. Ghosh, difficulties, this man is waiting outside since the year 2004.
Explaining the retrospective effect of it.
No charity has been done. His entitlement, government's policy decision, you have given effect to. So when you, Mr. Ghosh, when you give a policy decision, you give effect to a policy decision, you are also required to ensure that his seniority is not also tinkered. Because 2007, when he came up, he got an order of status quo. So that is different. Place the section, paragraph 11 of this judgment, 2007, 15, you have the copy. Here, what are the facts? The facts are different here. You see, facts you will find.
Disciplinary proceedings is there.
Paragraph 4. Place paragraph 4. Yes, Mr. Ghosh. Here the tribunal directed what he is really asking for from the date of his initial appointment, which was set aside by the Honorable Supreme Court. And the facts here are different than the one here. How many persons have you appointed? And what is his seniority? And how does it get tinkered with? Show me. Yes, where is that? No. You're not getting it, Mr. Ghosh. 2007 employment notice, how many persons have you appointed? Take instructions and come back. Listen to this. 2007, you have appointed employment notice 2nd of March. 2nd of March 2007. Page number 78, perhaps.
38 vacancies there.
Yes.
Total vacancies 38.
How many persons have you appointed? Because this is 2nd March. The court passed an order of injunction. And at your instance, no order was passed in his favor. The court said, very well, you take a decision in the matter. You waited for 4 years to take a decision. So the only question today for consideration is, subject to hearing you on that subject and seeing the documents, why he should not be regularized from the date of passing of the order passed by the High Court. I'll model that really, if at all he is entitled to. Hindi? Place it. Place it, yes. I now.
But apart from the findings, your lordship has it up to page 23. Paragraph 26.
Yes.
You want to be cheap?
In cases relating to service to the commercial taxes department of the High Court has directed that those engaged on individual treatment wages for the salary allowances that have been paid to be equal of their pattern and government market, which dated from the date from which they were respectively appointed. The objection taken was the direction element of the text of the indictment, we find that the High Court had clear or wrong in directing that these employees to be paid salary equal to the salary allowances that can be paid to the employees of their federal government services from which they were taken for amendment. It was not open to the amendment. Such an application of the same when the very question but if that is what equal pay or equal or support and was equal. Any other benefit, they are also being the directions of the system. We are therefore of the view that at best the division bench of the High Court the director that wages salary that are being paid for employees, we pay to this daily wage employees will take it from the
Judgment. Its judgment, not this. Its judgment. That means judgment of the High Court. So here also judgment of the High Court. And here I have ascertained from him initially what pay was he getting. So that he is by a backdoor process not trying to get a higher pay. No, he was getting the pay is not affected at all so far as he is concerned.
and retrospective.
When you want to come back, no, I will hear you again on this. When you want to come back, because the records have to be produced, you also cannot assist the court without the records. Yes. Having heard the learned advocates appearing for the having heard the learned advocates having heard the learned advocates appearing for the respective parties, I am of the view that the records of this case are required to be produced. Full stop. The respondents are also directed to ensure that the records in connection with appointment, if any, made pursuant to the employment notice dated 2nd March 2007 affidavit korte bole the report. The respondents are also directed to file a short report disclosing therein appointments, if any, made pursuant to the employment notice dated, where is that employment notice gone? Employment notice dated 2nd of March 2007. Yes. Issued by the office of the chairman, selection committee, district judges court, who, Purbo Midnapur. Full stop. The respondents are also directed to indicate in the said report the seniority of the petitioners vis-a-vis any person appointed pursuant to the aforesaid employment notice. The records independent of this record ache to upore bolche. Let such report in the form of affidavit be filed on or before the matter is taken up next. List this matter in the month list of May 2020. Hey, na month list of May 2020 korte hobe. Keno? Date diye ni to kono. আমি বলিনি তো কোনো না ধরতে যাওয়া হবে না। 2012 মামলা তো মান্থ লিস্টে দিয়ে দিলেই ধরে নেবে। হ্যাঁ, Mr. Ghosh, I have called for the records. A, B, I have directed you to file an affidavit. Report in the form of an affidavit disclosing A, how many persons have, if at all, been appointed, and the seniority of the petitioner vis-a-vis those appointed. Followed. On or before the matter is taken up next, monthly list of May. Respondents have said, hey, देखिए आएगा फाइल टा काके दिए ना district judge is a party. Oh no, you are representing yeah, record state respondents, and any other respondents are being represented. You will be having all the records. Orderটা না স্টেট রেসপন্ডেন্সের উপরে। Someone on behalf of the principal secretary has to file. As long as it is with authority, there is no difficulty. If it is without authority, then it is a lot of difficulty. No, principal secretary. This point number 2 and 3. This point number 2 and 3.
20.
For this one, 3 and 4, Lord. 4 and 5. I for this one, 4 and 5.
You are appearing, Mr. Singhania, in this matter?
Yes, my lord. For this one, number 4 and 5.
Very well.
Lord, it is that matter, my lord. Some of the employees, my lord, have died. Your lordship, whether they would proceed with the matter or not, affidavit is to be
I
filed.
have to dictate, I have to hear out and dispose of your matter. Not possible today.
Yes, I have seen it, my lord, subject to lordship sanction.
Monthly list of March, May, I'll place it.
Oh, your lordship, keep it intact, this matter. Take it up tomorrow or any other day, my lord. Otherwise, if it is not included in the daily list, I think.
No, now you see, these are 2012 matters.
I'm not insisting, your lordship.
No, these will be taken up. Ordinarily, 2010-12 matters are called on, even in the monthly list. And I do not know, monthly list of May also, I'll only have
your lordship,
weeks time.
yes, there is
So
no
that
idea.
is why I'm placing
Yes,
it.
yes, yes,
If it cannot be made effective. I do not know what will happen. That's why I'm placing. And I'll be having the determination in the morning. I'll take up those matters. In the afternoon, I'll take up these matters. So if I place it in the supplementary list, you may not be at all called on.
Due to changing determination.
Yes, so it is easier that I will place it in one list this matter in the monthly list of
May
2024. Wait for a while, I'll take it up. I still have determination. Service matters, I am having determination.
Yes, yes. When I have seen the notice, I was afraid of that matter.
No, it is there.
Grateful to your lordship.
And in fact, I was not taking up the current matters also. I could not touch generally, I could not touch 20, 21, 22 matters, except for a few.
Yes.
So it is better that way.
21. 21 and 22. Lordship, can you take it here tomorrow? Today I have not at all.
Monthly list me, I'll place it.
Monthly list, it will delay.
Monthly list me. You have to argue this matter.
Yes, I have argued so many times.
I have heard this matter.
Yes, your lordship heard the matter.
Once only. Only once. You just opened the matter once.
No, your lordship twice or thrice. Your lordship heard the matter.
Just remind me what is the facts.
It is petitioner Ballard promotion was withheld on the ground that his 5 years record of service are not satisfactory. But Ballard, that record of service, Ballard, before self-appraisal, the adverse remark which was recorded, that was not communicated to.
Records are here.
Records are very old. Those records are not preserved for so many years. Those records are not preserved for so many years.
When was the writ petition filed? 2012.
12.
So the matter was there. Ascertain from your officers whether they are there or not.
That we had asked. But I've been told that till now they've not been able to.
No, now there will be a direction of the court, so it will be easier for you. It will be easier for you. Because the records will ultimately only help you.
Very well.
For a respondent, you see, always the entire documents are not even shown to their advocates. It is only when the records come that you get to see.
Let there be a form.
Yes, I'll help you. Let the record, having heard the learned advocates for the parties, I am of the view that the records of this case is required to be produced, full stop, in view thereof. I direct the respondents to produce the records of this case when the matter is taken up next. Place this matter in the monthly list of May 23. It will only help. If you do not get it, then we shall see.
Both 21 and 22.
Yeah. It's appearing together only.
No, there's one thing that I need to indicate, Millard. So far as the first matter is concerned, DPC was held there. So far as the second one is concerned, there was no DPC. Therefore, there is no question of producing.
Only first DPC. Yes, naturally. Without the DPC, what records will you produce?
Since he was saying that the same direction for the second matter,
the petitioner is entitled to say so many things. Ultimately, it's for the court to pass the order in favor of the petitioner, if at all, and for the respondents to demonstrate before the court that he is not entitled to that relief. You know.
The last occasion, Lordship desired to get the inquiry and proceedings of the
Yes. Who is appearing? Dekhi file ta.
Mr. Boidurjo Ghoshal for the bank. On several occasions, Lordship allowed them to produce the records. But my lord, one thing I can assist your lordship, that page 75 will speak for itself of the writ petition. Page 75 of the writ petition will speak that who is the disciplinary authority and the chairman.
My lord, kindly pray for short.
Page 75, my lord.
Lordship praying for
Annexure P6.
Yes.
The same person, kindly look at yours faithfully, disciplinary authority and chairman.
So I remember you now your contention. Your contention is same gentleman had heard the appeal.
Yes, my lord. And that's why chairman did not put his signature. Simply other 5 members they have put their signature. So this is a violation of.
Where is the record?
Praying for short passover, Mr. Ghoshal.
Where is the record?
Captain is senior.
Who is your senior?
Mr. Boidurjo Ghoshal. Lordship praying for short passover, my lord.
Please wait, kindly wait. I'm passing it over. Let the records come. Call for him.
Yes.
এই পাস ওভার এখানে থাক, ওপরে থাক, নাহলে পারবেন না। হ্যাঁ, ওপরে রাখুন, নাহলে হারিয়ে যাবে, সব মিশে যাবে।
24.
For the petitioner.
I'm led by Ms. Rajeshri Kundalia. I'm praying for not today. She's in some personal difficulty today. I'm praying for not today. She's in some personal difficulty. I'm led by Ms. Rajeshri Kundalia.
Not today.
Official, and he's rendering his duty since 2002.
Some difficulty. Why are you making submissions? Yes, not today, Rapo. Or you want it later? Not today or not this?
Not today.
Not today.
Yes, your lordship.
Okay.
25.
I am appealing for the petition.
I am for the respondent.
I am filing the reply to their opposition.
Yes, continue.
Lord,
what is the matter?
The same reply. হ্যাঁ সেম রিপ্লাই স্যার আপনাকে তো দিয়েছি না আমি পাইনি রিপ্লাই কপি দেওয়া হয়নি স্যার আপনাকে? না রিপ্লাই দেওয়া হয়নি স্যার। আমাদের রিপ্লাই কোনটা হবে? লিখে রেখেছো পাসওয়ার্ড লিখে স্যার একটু কাইন্ড না ওটা অর্ডার পাস পাসওয়ার্ড। Lord, here is a matter for compassionate appointment. My father died. Thereafter, I applied for the compassionate appointment within time. Thereafter, they rejected my claim. But Lord, what has happened in the meantime? After my application, they did not do anything. I filed this application. Thereafter, subsequently, a file of this application, they rejected my claim.
When did they reject?
Your Lordship, kindly. Your Lordship, kindly take up their opposition.
You tell me when did they reject? You not gone through the brief?
Yes, Your Lordship. 2013, Lord.
Yes.
But thereafter, what has happened? They have taken that plea in their opposition. Against that, Lord, I have a twofold submission to make before us.
Where is the order of ejection? Mr. Chattopadhyay, where is the order of ejection?
At page 11, R1. Opposition, my lord. And they have stated in their paragraph number, your lordship, paragraph 7 and 6 and 7 and 8.
Nothing.
Only two things.
This is a copy of the recruitment policy.
Recruitment policy.
Where rejection? Where is the rejection?
This is their proposed.
For the matter being, my lord, dealt with by the authority, my lord, the
I filed.
petition was filed. Now, my lord, this is a case, my lord, where, my lord, this cannot.
When did his predecessor in interest die?
India 2013.
My lord, our
2012, 18th of April 2012. My father died. I applied on 28th of May 2012. It is at page 17 of my application, REIT application. And that was duly forwarded by them, my lord, in the year 2012, on June 2012, 23rd of June. It is at page 22. And thereafter, they did not do anything, Lord. I filed this writ petition. And in this application, they filed this opposition and they said that, my lord, my application has been rejected on twofold ground. One is on terminal benefit, and second is that there is no.
Where is the rejection order?
Rejection order they have not supplied.
Then?
My lord, before that is my I submitted.
That is your opposition. You have said that you have rejected.
Have rejected, my lord, but
where is the rejection?
That I have not annexed, my lord. I'm not annexed.
Now you will prepare it and bring it, Mr. Chattopadhyay.
No, my lord. I have said, my lord, can you come to pay?
Yes. Then why you not annexed it?
Paragraph 6.
Yes.
Have, my lord, detail, my lord, why, my lord, it was not considered.
Details was given, but my lord.
I will not annex, Mr. Chattopadhyay, because it was not available with you at the time of preparation of the affidavit.
I have
knowing you, Mr. Chattopadhyay.
have to take a responsibility. It's a return.
Yes, no. Knowing you, Mr. Chattopadhyay, you will never, if you have it with you, never hold it back from the court. So you did not have it with you. Obviously.
No, since, my lord, it was.
It was only parawise comment. It has been rejected. What is this, Mr. Chattopadhyay?
That's why, my lord, I have annexed, my lord, our recruitment rule.
Where is the law on the subject that 4 square meals have to be taken into consideration? Where is your consideration on this? Show me the order. No, I will not see any order. Page
30. Our rules itself.
Rules is not there, not necessary. Rules is acceptable. Whatever is the rules, I'll accept. Your consideration, how did you consider? Show me.
Let me produce one of the records. That will be better.
Now records.
My lord, it's
It will not be easy, Mr. Chattopadhyay.
13 matter, my lord.
Compassionate appointment, it cannot throw a person out like this.
No, definitely there must have some decision, my lord, adopted, my lord, before, my lord.
You are not aware. See the situation, Mr. Chattopadhyay.
My lord, this should have been, my lord, enclosed with the affidavit of opposition, my lord. It's my lord. I'm sorry, my lord. I have to take responsibility because I'm now moving this matter. But
Do you say that his claim for the compassionate appointment has been rejected?
The ground of my lord against my lord.
Do you say it has been rejected?
Yes, sir.
Where is your statement?
Well, paragraph 6.
Why married daughter is not a dependent?
No, that is no.
Married daughter is not a dependent.
Cannot go, my lord, beyond what our rules is.
Now, what is your rule? Show me.
Page 13.
Yes, show me.
Page
Yes.
13, my lord, of my opposition. Page 13.
Yes.
Rule 6.
Huh.
My lord, considering the plight of the family after an earning member dies or becomes physically incapacitated, one of the dependents of the employees who died in harness or had been declared physically incapacitated by the medical board constituted by the company, irrespective of the pecuniary condition, the family may be offered employment in class 3 or class 4 post subject to the following condition. Dependent of an employee shall be eligible to apply for employment under this category provided such death in harness retirement occurred on or after 6 June 2005, and also the dependents did not receive any financial compensation in lieu of employment. Upper age limit shall not be more than 40 years for the spouse and 30 years for the other dependents as on the date of the death or premature retirement on.
This clause is violative of Article 14, this G.
Yes.
I have a just make a distinction between a son and a daughter.
But
this makes a distinction between a son and a daughter.
Policy, my lord, was not challenged.
Maybe the court cannot shut its eyes.
But we cannot go beyond, my lord, what our rules.
That the court will consider. You see, Mr. Chattopadhyay, an unmarried son, it does not provide that an unmarried son. It says none other than the son and unmarried daughter.
Daughters are there.
Why is it that not unmarried son? Why is it that an unmarried son is not only included? Why do you include a married son? Tell me. Give me a reason for this. We are discussing on this. Give me a reason. What is the difference between a married son and a married daughter?
Sir, my lord, always, my lord, gets a new status, my lord, after marriage. Always.
What is the new status, sir?
My lord, after marriage, my lord, son, my lord, remains, my lord, in the same family. But my lord, daughter, my lord.
Family? Are you sure?
My lord, to that extent, my lord. My lord, presumed to be, my lord.
Sorry, sir. Sorry, sir. A married daughter may look after his mother, may be employed, may be unemployed,
but my lord,
may be having a husband who is not looking after, may be having a husband who is not looking after him, or maybe a person who was solely dependent on the finances of the person who has died.
My lord, maybe, my lord, my lord, this may possible, my lord, but my lord, these.
So how do you make a classification amongst them? What is the basis of your classification?
What is, my lord, this rule is, my lord, what is there in clause 6G, my lord? How can we go, my lord? I'm asking myself to go beyond the rule, my lord. It is
petitioner is a married daughter.
Yes.
And what have you stated in the petition? Let's test out. Let us test out without
I
calling upon them.
Categorically
Let us test out before calling upon them. What is your averment?
Averment at paragraph number 7.
Yes.
At paragraph, Lord, I have stated that your
whether it will become academic or not, that is necessary.
When I have a judgment also.
Judgment will come in later.
Yes, yes, Lordship. Whatever fallen for Lordship, that is depicts from these judgments also, Lord. It is a division bench judgment as well as Lord.
Yes.
But at paragraph number 7 of my writ petition, I have stated that, Lord.
Permanently residing with the father.
And she's main criteria.
Have you said that she has no independent source of income?
No, dependent, fully dependent on her father. That means not she has.
Very well. Show me the judgment.
Your Lordship, this is the judgment.
এই আইটেমটা আছে না, ওটার ব্র্যাকেটে 2 লাগিয়ে দেবে, তো পাসওয়ার্ডটা যদি না আসে আদার সাইড 2 করে দেবে ব্র্যাকেটে, ওই নম্বরটা দিয়ে 2 লাগিয়ে দেবে। তাতে কি হয়েছে ভেতরে, তো ওটার থেকে হ্যাঁ রেখে দিও আমাকে, তোমারটাই তো।
Same, Lord, electricity board. This is also electricity board matter. This is also a electricity board judgment, Lord. It was passed in the year 2018.
This is not a division bench judgment. This
is not division bench judgment. This is single bench.
There is a division bench judgment.
That has been stated here. Dhara 4. Lord.
Purnima Das.
Purnima Das. That has been cited here, Lord. At paragraph number, your Lord's page
Yes,
second.
Mr. Chattopadhyay.
Purnima Das, my lord, is someone different. Well, I can, my lord.
Are very well. So there is no order of rejection.
There is no, my lord, that is not on the face of the record, my lord, there is no order of rejection.
I'll record that.
I have not been communicated also.
Since
I'll
my
record
lord-
that.
Since my lord, it's a, my lord, written brief, my lord. I have to take responsible, but I have not.
এই এর আগে কটা নট টুডে হয়েছে? এর আগে কটা নট টুডে হয়েছে?
দুটো হয়েছে, প্রথম দুটো।
এইখানে it says or come with the records, Mr. Chattopadhyay. Come with the records. I cannot take up your matter further. Today I cannot continue. 25 তো। রাখো। Come tomorrow. Whatever order I'll pass, I'll pass. Today I don't have time.
My lord, if your lordship kindly longer time, my lord, I can bring the record.
I'll decide. Consider it tomorrow. Today I have no
Yes.
time.
Yes, it is there.
Come tomorrow, not today only. I've heard you, but if I have to pass an order, I have to consider this. So tomorrow I'll do. What are 25 বলা আছে না?
Grateful to your Lordship.
Tomorrow it will be there. Where is that gentleman? He is not here in court. Audience এ ডাকা যাবে না। ডাকুন any urgent matter বলে ডাকুন। Very well. ওডি করে দিন।
Reply may be kept on the record, my lord. I have filed this.
ওর রিপ্লাইটাই ফেরত দিয়ে দাও। রিপ্লাইটা ফেরত দিয়ে দাও। কালকে নেবো।
My lord, item number 3 in the original side, my lord, the records were called for, my lord, I have the records. I have the records, my lord, the records were called for.
Tomorrow, madam, not
Yes,
possible.
yes.
ঠিক আছে।
Yes,